file an application to include the new DC.
Okay.
3 weeks.
Seven.
Yes. Okay.
Please, Your Lordship. My Lord, I beg to mention item number 3. Lord, allow me to refer this petition with liberty to file a phrase. No, my Lord, respondent has appeared. The state respondent is for both the respondent. For the state in the complainant. Yes, my Lord. My Lord, I also beg to mention item number 16, my Lord. On behalf of Himatushi for respondent number 2.
My Lord, I'm appearing for the accused in this matter, item 16.
My Lord, if this can be listed after 2 weeks, my Lord. But
You're for?
I'm for the petition, my Lord. I'm for the petition. My Lord, can it be listed after 4 weeks' time, my Lord? I'm an outstation lawyer, my Lord, for the final hearing.
my Lord,
Okay. On the prayer of both the Land Council parties, this is matter after 4 weeks. Okay.
oblige, my Lord.
Lordship, there's an interim, Lordship. There's an interim in this.
Okay, you are for?
I'm for the petitioner, Lordship.
Okay.
Yes.
My Lord, in item number 16, there is an interim order, my Lord.
The interim order passed earlier shall continue till the next stage.
Lordship. Much obliged. May I please, Lordship? Lordship, I beg to mention item number 17, Your Lordship.
17.
Yes, Lord. On behalf of YP Gupta, Your Lordship. There's a personal difficulty today, Your Lordship. So I pray that this matter will come out of 2 weeks, Lordship.
For the petitioner.
For the respondent number 5, Lordship. I'm for respondent number 5. Appearing on behalf of YP Gupta.
Miss,
For petitioner.
Miss
Esther, Your Lordship.
Esther, Land Council for the petitioner is present. Mr. Medabaro, Land Council submits that the Land Council for the respondent number
5.
5, he has some difficulties to this and pray for adjournment of the matter for
2 weeks, Lordship.
2 weeks. The prayer is allowed. List is matter after 2 weeks. Okay.
Obliged, Lord.
No.
Your Lordship, I can beg to mention item number 21, Your Lordship.
21.
Yes, Lordship. Lordship, here, my senior PP police has taken leave, Your Lordship. So if this matter may come up after 2 weeks, Lordship.
For a petitioner.
Yes, Lordship. No, Lordship. Respondent, Your Lordship.
Oh. Yeah, Mr.
Akumair.
Hmm?
Akumair.
Kohima Land Council for the petitioner is present. What is your submission? You said PP Paul. Okay.
Yes, Lordship.
He has some difficulties.
Lordship.
Okay. Similar order, Mr. Medabaro, Land Advocate submits that petitioner, Mr. PP Paul, has some difficulties to this and prays for adjournment of the matter,
2 weeks,
to
Lordship.
which the Land Council for the petitioner has no objection. He has prayed for come. This is matter after 3 weeks.
Lordship, there is an interim.
Interim is also there.
Yes, sir.
The interim order passed earlier shall continue till the next stage.
Obliged, Lord.
Please, Your Lordship.
Hmm.
Lordship, I beg to mention hearing item number 20.
Item 20.
Yes, Lordship. Lordship, here, I'm appearing for respondent number 6. Lord. Lordship, I have some difficulties today, so if this matter can come up after 2 weeks, Lord.
Okay. Mr. M. Sololari, counsel for the petitioner is present. Ms. Rosina, Land Council appearing on behalf of the
Respondent number
respondent
6. Lord.
6, submits that she has some difficulties to this and pray for adjournment of the matter for
2 weeks, Lord.
2 weeks. The prayer is allowed. List this matter after 2 weeks.
Much.
Obliged, Lord.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 18, hearing item. I may bring from my senior Your Honor, Your Lordship. For respondent 1, 3, and 6, Your Lordship. I waited if this matter could be adjourned for 2 weeks, Your Lordship.
Petitioner is present.
Yes, Your Lordship.
Mr.
Nokulai M. Punyak.
Non-counsel for the petitioner is present. Mr.
Jingyang Pom, Your Lordship.
Appearing on behalf of Mr. Yangabati, non-counsel for the petitioner, prays for adjournment of the matter to which the non-counsel for the petitioner has no objection. He is prayed for, list this matter after
2 weeks, Your
2
Lordship.
weeks.
Lordship, there is an interim, Lordship.
Para. The interim order passed earlier shall continue to the next stage. Okay,
Lordship, I'm for respondent 2, 2, 4, and 5.
here,
Yes, Lord.
okay.
Item 18, 2, 4, and 5.
Mr. Sigafote, non-counsel for the respondent number 2, 4, and 5 is also present. Okay,
Your Lordship, similar prayer on item number 22, Your Lordship.
32.
Yes, Your Lordship, for all the respondents.
The petitioner is present.
Yes, sir.
Yes, Lordship, I'm for the petition.
No objection.
Objection.
Mr.
Jingyang Pom, Your Lordship.
Non-counsel for the respondents,
Yes, sir.
prays for adjournment of the matter for
2 weeks, Your Lordship.
2 weeks, to which Miss
Vikono Gisa.
non-counsel for the petitioner has no objection. Stop. The okay, according to the prayer is allowed, list this matter after 2 weeks. Okay,
Obliged, Your Lord.
My pleasure, Lordship. Lordship, I beg to mention item number 15 on behalf of my seniors in the Young Lordship. Lordship, this matter may come be listed after 3 weeks, Your Lordship.
Respondent.
Appellant.
you are for appeal.
Yes, Lordship.
Okay, no objection. Mr.
Nokulai M. Punyak.
Non-counsel for the respondent. Your name is also there. Appearing your.
No, I pray on behalf of Saint Young.
Mr. Sankey, for adjournment of the matter for
3 weeks, Your Lordship.
3 weeks, to which Miss
Krovitsa, Lordship.
non-counsel for the petitioner, sorry, appellant has no objection. Stop. Prayer allowed. List this matter after 3 weeks. Okay,
Lordship, I also beg to mention item number 23.
23.
I pray that this matter may kindly be listed after 3 weeks, Your Lordship. On behalf of Saint Young.
Which for the respondent? State. Okay. Mr.
Nokulai M. Punyak.
Speaking on behalf of Mr. Stanton, pray for
3 weeks, Your Lordship.
adjournment of the matter for 3 weeks. To which the non-counsel for the respondent has no objection. Prayer allowed. List this matter after 3 weeks.
Your Lordship. Lordship, similar prayer for item number 24.
Santiago,
Yes, Your Lordship.
similar order. 3 weeks.
Yes, Your Lordship.
You are for respondent here.
Respondent number 2.
Okay. Then record are present also. Miss.
Rebecca.
Okay. The non-counsel for the respondent, Miss so-and-so and Mr. Zimomi, has no objections. Okay.
Deeply obliged.
My pleasure, Lordship. I beg to mention item 25. Hearing for the petitioner if this matter can be listed after 2 weeks.
You are for the petitioner.
Yes, Lordship.
Okay. No objection.
No objection.
Okay, Miss.
Krovi.
Probably should non-counsel for the petitioner. Prays for adjournment of the matter for
2 weeks, Lordship.
2 weeks, to which the non-counsel for the respondent, Miss so-and-so and Mr. Zimomi, there is no objection. Prayer allowed. List this matter after 3.
Lordship. There's an interim, Lordship.
The
Interim.
interim
yes,
also.
yes.
3 weeks. Stop. The interim order pass earlier should continue till the next stage. Okay.
Obliged, Lordship.
May I please, Your Lordship?
Yes.
My Lord, I beg to mention item number 4. Here we are yet to file our reply. Dear-
Let it be. Let it be called for.
Yes, my lord.
It won't take much time. Are you No urgency? Okay, be there. then.
For motion, item number 1.
May it please your lordship. Your lordship, I would like to beg to say that I may be allowed to withdraw my petition and to file a fresh.
Yes, there is a case where you have not implemented the victim also.
Yes, Your.
Okay. Miss,
Ketokrinyo.
Lana counsel for the petitioner must withdraw this petition with liberty to file a fresh. Prayer allowed. The petition dismissed on being withdrawn with liberty as prayed for. Okay.
Bachelor. For motion, item number 2. May it please your lordship.
Yes.
Lordship, this IA is for seeking continuation of delay of 31 days, Lordship.
Make appeal.
Lordship. The present appeal is for enhancement, Lordship, of compensation awarded by the tribunal, Lordship.
Mr.
Inti Wapang, Lordship.
Yes. Lana counsel for the applicant. Para. This is an application filed under Section 5 of the Indian Limitation Act 1966, bring for condemnation of delay of 31 days in preferring the connected appeal against the impugned judgment and award dated 14/6/2024,
Lordship.
passed
MSCP.
in motor accident claim case number 01/2023 by the learned member Motor Accident Claims Tribunal,
PEC.
PEC, District. Staff, huh? Para, issue notice returnable by 4 weeks.
Lordship.
Stop the petitioner. So the applicant shall take steps upon the respondents by a registered post with ID within a week from today.
Lordship.
Okay. List is matter after 4 weeks.
Highly obliged, Lordship.
For admission, item number 4.
Please, your lordship.
Yes.
My lord, here we are yet to file our reply to the opposition filed by the respondent. Therefore, I pray that 2 weeks' time may be granted.
Miss
Pim Hombeni Izum
Lana counsel for
for the petitioner.
petitioner. Submit that she has received. The copy of the affidavit in opposition filed by the respondent number 1, 2, and 3. And prays for some time to file counter reply to the said affidavit. Stop the prayer is enough. List is matter after
2 weeks.
2 weeks.
Oblige, my lord.
For admission, item number 5.
May you please, Lordship.
Yes.
My Lord, this is a bail application under 439 CRPC.
Yes.
My Lord, it is already a charge sheeted case. Charge sheeted. Charge sheet has been filed by the IO. So investigation is over and then charges are yet to be framed under 227 of CRPC. my Lord.
Charge not yet framed.
Not yet framed.
Date was fixed earlier.
Yes, it was
It was
adjourned.
fixed
Adjourned.
earlier, but time
Adjourned.
and again, they have been adjourning the matter.
Did
I
the
was-
charge be framed?
Yes,
My Lord,
Because at the time of framing charge,
lordship.
it will be hard.
Lordship may
Whether
kindly.
there is a prima facie
Lord-
case against you or not.
Lordship
it
may
is
kindly
decided-
consider the bail today because I have, whether a charge is framed or not, I have cited the thing. Where I'm the driver. I'm the driver. Accused to. There I have, and that's all the document till today, whatever material collected by the IO till today, till at the time of charge sheet, nothing is against me. So therefore, according to my humble submission, I'm an innocent victim. Nothing, I'll satisfy lordship today. And I have a lot of judgment from passed by own High Court, Guwahati High Court, my lord. I'll just satisfy the lordship. After the lordship can pass any order, my lord. Lordship will see.
Record has been called for here in
Call.
this case.
Record has been called for, and lordship, there is a prima facie against the accused, lordship. There's
My lord,
the charge sheet will speak for itself, lordship.
charge sheet, I have an next charge sheet. I have an next everything.
They have annexed, and then lordship, this is the scanned copy of the lower question.
My lord, record can be seen now, bro. I have filed charge sheet, no doubt. I'll show. Before that, if lordship sees my bail application, that is bulky, but I have a next relevant document, everything in the bill. I have not hidden anything, my lord. May I read, my lord? Just simple. Here, out of 5 sections, 3 are non-cognizable.
Charge sheet under section 304 only.
304.
No, 302.
Out of 5. No, not 302, my lord. I'll satisfy lordship. Now, my lord, give me the ingredients.
So the IO has come into the conclusion that it is under 302 only.
Yes, 304. Well, this is the
No,
ingredient
304,
also.
304.
I'll show lordship the ingredient. I'll just show, my lord. Just to satisfy the court.
Now we need to see at the time of framing charge, whether the charge frame under 302 or 304.
My lord, in my humble submission.
Because how the IO can come into the conclusion that it is under 304 only.
Lordship.
It's very difficult.
Lordship, in my humble
Before trial, a person has been murdered, person killed. Now we do not know under 304 or 302, how the IO can come into that conclusion.
Lordship.
My lord, if lordship hear my application, then I'll satisfy the court. How it has come to that conclusion, my lord. Lordship will see, this is the first ingredient.
Trial is yet to begin.
My lord. Lordship.
Trial is yet to begin.
No.
Come into conclusion.
Trial me, it will be question of acquittal, my lord. This is bail stage, my lord. Yes. Now, in these similar security cases, Supreme Court as well, or on Guwahati High Court has rendered several judgments. I'll just satisfy the court, my lord.
Okay.
Yes, my lord. I have judgment. I'll just reveal everything to the court, so the court will decide, no problem. Now, my first submission before I open the bail application,
Yes.
lordship, I have said, there are 5 penal sections.
Yes.
5 penal sections, including 304. Now, lordship will see, I have supplied the copy of the ingredients, my lord. One is 290, punishment for
290.
My lord, lordship is with me. Ingredients, I have given you the ingredients copy, my lord. Yes, that's the one. Yes, I have printed out the ingredient, my
So
lord.
charge sheeted under 290 also.
My lord, lordship will just bear with me.
Okay.
Punishment for public nuisance in cases not otherwise provided for, that is non-cognizable, bailable, my lord. This is what is the offense? Whoever commits a public nuisance in any case not otherwise punishable by this court shall be punished with fine, which may extend to 200 rupees. We only with fine, no punishment, no imprisonment. That is one. Lordship coming down to 352. Punishment for assault or criminal force otherwise than on grave provocation, non-cognizable, bailable, my lord. What is that offense? Whoever assaults or uses criminal force to any person otherwise than on grave and sudden provocation given by that person shall be punished with imprisonment of either description for a term which may extend to 3 months, 3 months, not years, or with fine, which may extend to 500 rupees or with both. So this is non-cognizable and bailable, my lord.
Right.
I'm trying to satisfy my lord, your lordship. Now coming down to 323, my lord. Punishment for voluntarily causing hurt, non-cognizable, bailable, my lord. Now what is that offense? Whoever except in the case provided by section 334, voluntarily causes hurt shall be punished with imprisonment of either description for a term which may extend to 1 year or with fine which may extend to 1,000 rupees. This is non-cognizable and bailable, my lord. That's why I'm trying to satisfy the court, my lord. Now coming to 325, punishment for voluntarily causing grievous hurt. Cognizable, bailable. Though it is cognizable, it is bailable again, my lord. And what is the offense? Whoever, except in the case provided for by section 335, voluntarily causing grievous hurt, shall be punished with imprisonment either description for a term which may extend to 7 years and shall also be liable to fine. This is cognizable but bailable, my lord. Now, the only section left is 304, culpable homicide, my lord. My lord, what is culpable homicide? I have written down here. 304, punishment for culpable homicide not amounting to murder, cognizable, non-bailable. This is non-bailable. What is that offense? Whoever commits culpable homicide not amounting to murder shall be punished with imprisonment for life or imprisonment either description for a term which may extend to 10 years and shall also be liable to fine if the act by which the death is caused is done with the intention of causing death or of causing such bodily injury as is likely to cause death or with imprisonment either description for a term which may extend to 10 years with fine or with both if the act is done with a knowledge that it is likely to cause death, but without any intention to cause death or to cause bodily injury as is likely to cause death. Here, 304 doesn't attract in my case at all. I'll show through the statement under 1610 PC, under even in the charge sheet itself, my lord. Now I'll satisfy the court. Now, may I open the petition? I'll certify that this 304 is not at all attracted as per the finding of the IO as well as even the complainant himself. The complainant is the son of the deceased person, my lord. Now I'll take lordship to my bail application, my lord. My lord, please come to page 3 and para 3. I'll just start only the relevant part, facts. Page 3, para 3, my lord. May I read it? That the short facts in hand is narrated as under A. On 19/5/24, the complainant, Mr. Tejavizo B. Mesalhu, filed a written complaint to the official in charge of Kohima North PS to the effect that there was an untoward incident on 18/5/24 at Pulbari bus stand / taxi stand opposite to Oking Hospital, Kohima, at around 4:40 p.m. Accused number 1 and accused 2, my lord, I am for accused 2. Accused 2 was a driver. Were alleged to have involved in the incident, and due to such untoward incident, the complainant's father was hospitalized and subsequently succumbed to his injuries on the next day, that is 19/5/2024. This is the FIR. Now coming to his own statement, statement under 161, complainant statement, whether I have really been implicated or not, nothing, my lord. So I become an innocent victim, my lord. Now B. Based on such complaint, letter dated 19/5/24, Kohima North PS case number so-and-so under section so-and-so was registered for thorough investigation and prosecution under the relevant provision. C.
What is the name of the informant?
My lord, Tejavizo, my lord. My lord, may I take your lordship to attend page 4, page 14, my lord. The complaint letter.
No.
FIR.
That I have seen.
Yes. Okay. Then may I proceed again, my lord?
No, let us just
Yes.
let us see the
Statement of the complainant. My lord, I'll show, my lord.
You have annexed that?
Yeah, I have annexed. The statement of the complainant. Huh? Page 21, my lord. Come to page 21. Page 21, my lord. Lordship has NHE, page 21.
Yes, sir.
My lord, he is the complainant. Tejavizo Benedict. The first part is not relevant, my lord. The second para is relevant. His statement before the police under 161, my lord. May I read the second relevant part only? On reaching Pulbari bus / taxi stand opposite to Oking Hospital, the two accused persons parked their car Swift on the left side, and both the accused persons came out of their Swift car and approached towards their vehicle. Accordingly, his father asked him to stop their vehicle as he wanted to apprise the two young men to avoid such inappropriate behavior in public. As he stopped their vehicle, the two accused persons immediately came and forced open the door of the Bolero where his father was seated. As such, his father stepped out of the vehicle, and without any respect of the age, the two persons started verbal abusing his father, which led to an altercation between them. Responding to the situation, he turned off the car engine and immediately went towards his father, during which one of the accused person pushed him away and tried to take him down. Seeing this, his father approached to stop the accused person, but in a moment, the accused Nuzosetyo Kire punched him first and immediately punched his father on the face and had knocking him down on the road in a conscious state. As he saw this, he also noticed some blood oozing out of his father's nose and hands. He rushed to attend his father, during which he was deliberately punched twice by the accused. Nozo said to Kire, I'm the driver only, my lord. The statement of the complainant himself under 161 is clear that I'm innocent. I'm innocent. I have not involved at all in this case, my lord. Then if lordship is satisfied, then I'll come to the statement of accused one and two.
Just a minute, huh?
Yes, my lord. Lordship may kindly see that I have never involved in the incident. Here, Nuzo Seto Kire is accused one. I'm accused two.
He is the one who created. Okay.
Yes, accused one is the one who created problem.
No.
Accused two.
Accused two is the one.
No.
started.
Blowing horn 290 honking is. I was the driver.
He did not give side also.
Yeah,
He the one who created the situation.
Initially honking was allegedly honking was created by me, but that is bailable and non-cognizable also, my lord. The only issue involved here in this 304, whether I had really punched the deceased, whether I had really committed the offense, act of offense. One. Lordship, my kind, I'll draw your lordship attention to paragraph page 17, where accused one has stated the same, all corroboration, well corroborated that I have accused two, driver had not done anything wrong. Page 17, my lord. This is the statement of accused one, the same person.
Okay.
Nizo said. Page 17, my lord. Page 17.
Yes.
The statement of accused one, paragraph 2. Only the real because long. May I read it? Paragraph 2.
Read one.
1. Accused 1. This is Nizo said to Kire. I'm for accused 2. The accused 1, accused A1, Nizo said to Kire stated that on 18/5/2024 at around 10 a.m., his friend, the accused 2, I'm for accused 2, Kratzone Hure called him to meet. Accused 2, Kratzone Hure came with his car, Swift number so-and-so, and together they moved out towards Raju Point, and from there, they went towards Naga Bazar area and fueled the car. From there, they went towards Secretariat area to wash the car. On reaching there, they had 2 beers each, and after washing the car, they moved out from there around 3 p.m. towards the town area to have lunch at the Sumi Hotel located at Phulbari area. His friend accused 2, Kretzone Hure was driving and he was sitting in front on the front passenger seat. On reaching Raju Point area, the accused 2, Kretzone Hure started honking. He was continuously honking till Assam Rifles Gate area. Then they heard a vehicle, Bolero, behind them also honking repeatedly near Assam Rifle Gate area. As they looked back, they noticed 2 people in the Bolero, the victim Mr. K. Lawrence Mesalhu and his son, whom they did not know before the incident. On seeing and hearing them honk their vehicle Bolero, they, accused 1 and accused 2, got irritated and therefore they slowed down their car till our church area. As he looked at the rear viewing mirror of their car, he noticed the victim's hat, K. Lawrence, coming out of the Bolero and saying something, but they could not hear what the victim was saying. 2. Relevant part. On reaching Phulbari area opposite Oking Hospital, we stopped and parked our car, Swift, on the left side while the Bolero was stopped in the middle of the road, started shouting at each other. In the process, we went near to Bolero and he, accused 1, so-and-so, pulled open the front passenger Bolero door and the victim, K. Lawrence, stepped out of the vehicle angrily. As we continue verbal altercation with each other, the driver of the Bolero, who was found to be the son of the victim, came out of the Bolero and on seeing them shouting at his father, the son came forward. Then accused 1, pulled the shirt of the son, Tajavizo, and tried to take him down, and in the process had a brief scuffle with each other, during which the victim, K. Lawrence, first punched him, accused 1, on his right eye, after which he, accused 1, punched the son, Tajavizo, first and immediately punched victim Lawrence on the face, and as a result, the victim fell on the ground, fell down on the road unconscious. Then, my lord, I'll come to the statement of accused 2, page 19, my lord. Page 19. Same statement only, my lord. There is corroboration that I have not used my hand at all. Page 19. May I read it, my lord?
Yes.
This is the petitioner before this room of court. This is accused 2. Kretzone. May I read the first from the starting or?
It's okay. It's all the same.
Yes, same thing. Same thing that,
Yes.
now, Lordship, I'll just show the charge sheet again. Charge sheet. How the charge sheet, the relevant charge sheet was filed. Charge sheet was filed on 16 August 2024, and the charge sheet starts from page. No, start from page 23, but the relevant paragraph is page 31, page 30, page 32. Page 31, the story starts, but the relevant page is where the offense, where the finding of the IO was shown is page 32, my lord. second, second param on examination. May I start from there?
Yes.
On examination of two accused persons, it is found that is now after examination, after recording all the statement, this is the finding of the IOML. On the 18/5/24, they both went to secretary area in accused two Kretzoner's car Swift and consumed 2 beers each and at about 3 p.m. From there, they headed towards the town area, planning to have lunch at a Sumi hotel located at Phulbari area. Accused 2, Kretzoner Hure was driving the car and his friend, accused 1, Mr. Soinsokire was sitting on the front passenger seat. On reaching Raju Point, accused 2, Kretzoner started honking continually till Assam Rifle Gate area and did not notice the victim, late Kia Lawrence, or the Bolero behind their car. Near the Assam Rifle Gate area, the Bolero behind them started honking. Both of them, they are honking. Even the Bolero, the deceased son also honking. Honking repeatedly, for which they, accused 1 and accused 2, got irritated upon the Bolero behind them. Therefore, the accused 2, Kretzoner, slowed down his vehicle from Assam Rifle Gate turning area till out church, after which he started driving normally. On reaching Phulbari area, accused 2, Kretzoner, showed his middle finger to the traffic personnel at the traffic booth at Phulbari Junction. Upon reaching Phulbari bus stand area opposite Oking Hospital, they stopped and came out of their car and approached towards the Bolero. The Bolero behind them also stopped, and after which they started shouting at each other. Meanwhile, they, accused 1 and 2, went toward the victim's vehicle Bolero, and accused 1 pulled open the front passenger Bolero door, and the victim 1, Lawrence, stepped out of the vehicle angrily. As they continue verbal altercation with each other, the driver of the Bolero, son of the deceased victim, came out of the Bolero from the other side and came towards them, accused 1 and 2, because the deceased and his son also came towards accused 1 and 2. Then accused 1, Mr. So-and-so Kire, pulled the son of the deceased victim, and while they were involved in the brief scuffle, the accused 1, Kire, first punched the son, Tajavizo, and then ultimately punched the deceased victim, Lawrence, fell down on the road. His son rushed to attend his father, and then accused 1 again slapped and punched the son, Tajavizo, twice. So everywhere the circumstances is well changed, that I am not involved at all. I have not used my hand. Therefore, now I become an innocent victim, at least in this case, my lord. This is the charge, this is the finding. From the beginning, he said, on examination of 2 accused, means this is the finding, my lord. And lordship, as I have, this is a short matter.
So you have filed bail application before?
Yes.
Trial court?
Yes, it was rejected, my lord. Rejected on the ground that I'll show. I have a next, my lord. I have a next. Lordship, may kindly come to page 46, my lord. Page 46. And the last, the other part is page 48, my lord. 48. What was the finding? What was the reason for rejecting the bail is in the last. May I read, my lord, that in view of the above observation, since the case is at the stage of considerations of charges, trial will be vitiated if bail is allowed at this stage. So this is the reason of rejection. Now that is the reason. If lordship wants me to read the whole bail,
It's fine only. It's okay. So
my lord, here.
you have taken the same ground before the trial court?
Correct. Because the order was wrong. Because bail, lordship knows with your experience. With your lordship's experience, your lordship is well aware. Bail can be rejected on few grounds. One is if the investigation is pending. In this case, it is already charge sheeted. Another ground, if there is allegation of tampering or hampering the investigation, then bail can be rejected. That is not the issue here because it's already charge sheeted. Another ground can be if there is an allegation of running away from liberty of justice. He's a local man. Where is the question of where is the question of accused to running away from the liberty from facing the trial? So these are the grounds time and again Supreme Court, High Court has laid down. But the ground taken by the trial court is not correct. It's not it has deviated from the principle of criminal jurisprudence. Lordship I'll show if Lordship I'll show our own High Court judgment in similar situated cases. Several judgments I'll show now. Where in this kind of incident happen, and if accused of more than one.
Okay,
My-
yes,
May,
you want to show?
yes,
What is that?
judgment. Similar case, my lord,
Hmm.
passed by our own High Court,
Okay.
our own Gauhati High Court. My lord.
Okay.
I think this was passed by Justice Manish Chaudhary,
Hmm.
Manish Chaudhary in Gauhati, Assam case, my lord. My lord, just simple, short, same case, more or less same, my lord. My lord, I'll just read the whole judgment. It's a short judgment, my lord. Lordship, I'll
The
just
relevant
start.
portion, not.
Okay.
Hmm.
Then I'll just start from paragraph 3, page 2, page 3, paragraph 3, my lord. In the first information report lodged on so and so, the informant has inter alia stated that around so and so on 22/11/22, his elder brother, namely Dole, was waylaid by five numbers of accused person named in the FIR. When so and so Dole was on his way to his residence by the village road of so and so. According to the informant, all the accused persons physically, or more than one accused, even here, 5 accused persons, physically assaulted so and so Dole on his head. As Lakindos Dole was found lying on the road, he was taken to and admitted to the Assam Medical College and Hospital, Dibrugarh, where he breathed his last on 24/11/22. The name of the accused petitioner has figured as accused number 2 amongst the 5 accused person named in the FIR. Now I'll skip 4, the submission. 5. The statement of one eyewitness has been recorded under section 161 CRPC. The said eyewitness has stated about the presence of all the 5 accused persons at the place of occurrence. As per the said eyewitness account, one Juwandra Dole, named as accused 1 in the FIR, had inflicted the blow on the head of the deceased, and the accused petitioner, though a bystander with him, did not inflict the blow. The statement of other witnesses have also been recorded by the investigation of the case. Considering the progress made in the investigation of the case and the period of detention of the accused petitioner in custody since 25/11/22, this court is of the considered view that custodial detention of the accused petitioner for any further period for the purpose of carrying out further investigation appears not necessary, and if the accused petitioner is released on bail at this stage of investigation, further investigation of the case is not likely to be prejudicially affected, provided the accused petitioner continues to extend his assistance and cooperation in the further investigation of the case. So now, accordingly, bail was allowed to do the other 4 accused. Same, my lord, out of 5 accused.
He was a bystander.
My lord, he's a bystander. He was also there very much at the place of occurrence, my lord.
But the present case is different.
My lord, present case also, he had never used his hand. He had not participated in the crime in the commission of the crime, my lord. My lord, another judgment, similar from our own High Court, my lord. Paragraph 11. My lord, this was our own High Court passed by Justice Hetish Kumar Sharma. Page 2, my lord. Page 2, on perusal. May I start from there?
Yes.
On perusal of the materials in the case diary, it appeared that this deceased died due to the assaults and injuries inflicted on him by one Rafiq Uddin. The present accused petitioner was with him at the relevant time, but no role has been assigned to him in commission of the alleged offense. So far, the evidence so far collected, considering material on in the case diary as well as the length of detention of the accused petitioner in custody, this court is of the view that his further judicial detention is not necessary in the interest of investigation of the case. My lord, next. This is also, my lord, on High Court.
It's fine only, I think. That's enough. So, any difference?
My lord, principle, even the, yes,
Any difference here?
same principle, because same principle, because when some of the co-accused had not participated in the commission of the crime, at least bail is granted, because further detention till the trial is over, it'll amount to violent infringement of the liberty of life under guarantee under Article 21 of Constitution of India. Yes, this case is fixed for CC, constitutional charge on 5th of November, 5th of November, yes. But my humble submission before this court is, if this court, since this court has undergone the statement of the accused 1, accused 2, the charge sheet, even the statement of the complainant, where no one has stated before the police that I had used my hand against the deceased person on that unfortunate day. So therefore, prima facie, even after trial, acquittal chance is very high for the accused too. So therefore, at this stage, at least during pending trial, the accused too should be allowed to be released on bail. This is my humble submission, man. And that is not going to cause any prejudice to the investigating case, because charge sheet is over.
The trial court has observed the case is fixed for consideration of charge. It was fixed initially 26/9/2024.
Yes.
What is that? And there is a prima facie case against the accused. So this is bail application only.
Bail application only.
What situation has changed thereafter?
No.
Your submission probably has appreciated here in the bail order also.
My lord, because the rejection order was, this is my humble submission, the rejection order unreasonable. Bail is normally rejected as per the judgment of Supreme High Court.
This is subsequent bail only.
My lord, subsequent bail.
Not under challenge.
No, my lord. As far as criminal law is concerned, there is no appeal. We have this.
No appeal.
Yeah, we have to not necessarily to challenge. Only point out the legality, illegality, my lord. So now the rejection order passed by the.
Now on the same ground, your bail was rejected by the trial court.
So finding was wrong. This finding was perverse. That's why I'm saying I have come before the court because for that reason. Because see, look at lordship have seen. Now the only reason for rejecting the bail is that now it is already fixed for CC.
That is why let the trial court charge frame against the accused. Let us see.
My lord, in that case, let it fix on 5, my lord, for hearing bail. CC, no. It's fixed on 5th November. So in that case, let it be fixed on.
Let a charge be framed.
Yes, no problem. After that, I can argue on it, no problem. Of the next day, having a calendar. 6.
Because on the same ground, how do we
7.
appreciate? It will be difficult.
This for CC is fixed on 5 or 4? 5. My lord, according to my junior, it's fixed on 5. Is fixed for CC on 5. So in that case, let it be on 6.
And then in that case, the situation will change.
Yeah, let it be on 6.
Wait for the situation to change.
And
in the meantime, this bail application goes.
Let it be on.
In the meantime, this bail application at the moment, since there is no any new ground that you have taken, because we cannot reappreciate the same ground on the same ground. How do we grant, Lord?
My lord, otherwise judgments are simple and clear.
You will have new ground
Lordship,
in that case.
Lordship. So this bail may either be dismissed or.
So that is why I'm saying.
Yes, Lordship. and to file a new. Lordship.
You come back with a new ground.
Lordship.
I'm rejecting it.
This court has the discretion to pass any order.
Lordship, because I've seen the others also. It appears that, so your submission is, I appreciate your submission for your client, but then it appears that from the record, he is the one who has created. It's not the same as you have cited.
Lordship. So,
Judgment.
in fact, 34
He was
IPC
a
is
bystander
affected.
and the other one was,
Lordship.
did not do anything, but here is a case where he
Lordship.
is the one who has started.
Lordship.
Irritated. He himself has created. And then you say, this is also not sure, but then the FIR was lodged and registered under 302. But charge sheet appears has been filed under 304.
Lordship.
And then it's court will, I think, after hearing the argument on perusal of the records, probably may also change.
Lordship.
So let us see. I'll pass order.
Lordship.
March order.
Okay, so land council for the petition. I've also heard Mr. Zimoni, land PP. So dictate of the chamber.
March.
Okay.
May I please, Your Lordship?
Yes.
Lordship, my apologies. However, in item number 4, there is an interim.
Item?
Number 4.
Oh, there is interim.
Yes, I pray that the interim may be continued.
Item 4 in the interim order pass earlier shall continue till the next date.
Obliged, my lord.
For orders, item number 6.
May it pleases your lordship.
Yes.
Lordship, I am appealing for the appellant, my lord. My learned on the earlier occasion, it was directed to serve a copy on the other side, my lord, which I have done, my lord.
What is this IA for?
IA is for condonation of delay, my lord. In filing the restoration petition, my case was, MSC appeal was dismissed for default, my lord, for non-appearance on during the time of COVID, my lord. Later on, after the COVID, my lord, what happened, I could not follow up with the case, my lord, which I have detailed in admitted in the miss case, my lord. There was some miscommunication because during the it was listed during the time of COVID, my lord, and during that time, my lord, I could not follow the case.
May it please your lordship.
Yes.
Lordship, I'm for the respondent number 1. Lordship, by order dated 22/7/24 of this honorable court, the appellant was directed to take drastic steps upon respondent number 2. Lordship. By order dated 22/7/20. So the notice has been completed.
Just a minute.
1 and 2.
Respondent number 2
Lordship.
is a legal manager, ICCC.
So whether
Your
respondent number 1, Lordship.
1.
Lordship.
And then the 2 is also
No,
ICI
Lordship.
only.
Respondent number 2 is
Legal
Kiran Das.
manager. Is all
The driver.
you are representing the general insurance.
No, Lord.
Insurance company.
My lord, I am appearing for the general insurance. I have filed the petition, my lord. I am for ICICI Lombard.
This is applicant. Sorry.
My lord, my lord.
Number
1, Lordship.
1. Okay. 2 is the another person.
My lord.
For dusty service, or it has been ordered on 22/7/20.
This is in the MAC appeal.
Lordship, the MAC appeal was dismissed.
Appeal was dismissed.
Lordship. And then they have filed the restoration. However, for filing the restoration, there has been a delay. So this IA is for delay.
Okay. You have any objection?
Lordship, I have, Lordship.
You have
But
objection.
prior to that, the notice has to,
Hmm?
the notice has to be completed, Lordship.
Are you filing objection? Filing objection.
I'll be filing, Lordship.
How many days of delay?
99 days as per their
99 days.
their statement, Lordship, as per their statement.
What is the stage of the MAC appeal
The MAC appeal was in the stage of admission, Lordship.
admission?
Lordship. If I'm
So
not
the
mistaken.
order was passed against this applicant,
The applicant, appellant.
okay, to pay the compensation amount.
No, Lordship, for non-prosecution, the appeal was dismissed.
No, but then the prayer was, yeah, your prayer was, then his prayer, your prayer, what was your prayer
In the appeal,
in the appeal on the amount? What is your appeal about?
My lord, my appeal was that there was no fault on the part of the insurance, my lord. It was the fault on the part of the driver who rashly and negligently, without having proper license, my lord, he has caused this injury, my lord. And as such, this accident occurred, my lord. That was the main subject of that MSA appeal, my lord.
And then this, so respondent number 2 is a driver.
My lord.
This appearance is necessary then.
Lordship.
My lord, may kindly do me a favor, my lord. My lord, may kindly allow me to take register post, because this person, I could not find him to take the justice service, my lord. On the earlier occasion, some counsel appeared, my lord, for the respondent number 2, but now this time none appeared. So once I have taken steps on respondent number 2 through register post, again I may be allowed to take register post, my lord.
Just a minute. In the appeal earlier, did you
My lord.
put it the amount?
No.
Half of the amount before the court at the time of
No,
filing
my lord,
the
no, my lord. No, my lord, there was a stay, my lord.
at the time of granting stay, there is no order for the order directing.
In the MSA, yes, my lord. I'm sorry, my lord. There was a stay, and we have done it, my lord. We have paid the amount.
Amount means?
And I will verify. Amount, my lord.
How much you have deposited the amount? How much amount you have deposited before the High Court? Is there any direct?
My lord,
Have you received any amount? You are for the claimant or
I'm for the claimant, Lordship.
have you received any amount?
Lordship, the other appeal is not with me, so this is only.
My lord, may kindly give me a few days. I will file an affidavit along with the documents, my lord, even if I have paid, my lord.
Anyway, in any case, you since your prayer is that it should be directed against a driver, then driver is
Lordship.
okay. Hard Miss Sumi Gauhati, now counsel for the applicant, who submits that the stay could not be effected as directed by this court, as the address of the respondent number 2 could not be traced out. Could not be traced out or what?
My lord, could not be traced out, my lord.
Traced out. Hence, pray for allowing her to take steps upon the respondent number 2 by a registered post with AD, as well as AD. Okay, stop. The prayer is allowed. The applicant shall take steps upon the respondent number 2 by a registered post with AD within 7 days from today.
My lord, let it be 2 weeks, my lord.
Within 2 weeks from today. List this matter.
Any date, my lord.
List this matter. You want date?
A date may be fixed, my lord. It will be convenient.
Then it will be since you are praying for two weeks and it is in the
My
lock time, then it will be listed only on November 18.
My lord, any date, my lord, as per the convenience of this honorable court, my lord.
Okay. As prayed for by the Lana Council for the applicant, list this matter on 29 November Submiss, this presence also be recorded.
Empty wapa.
MT Wapang. Learned counsel for the respondent number 1, claimant Mr. MT Wapang is
Lodge.
also present. Okay. Okay.
Obliged, Your Lordship.
Hello.
For orders, item number 8.
Your Lordship.
Yes.
Lordship,
I'm for respondent number 1. And this is the first time I'm appearing, my lord.
Okay. Mr. Usigopati, learning counsel for the petitioner. Staff, huh? You have filed your power? Wakalatnama?
No, my lord.
Okay. Mr. Tak.
That only CGC.
Sorry, Lane. Would appear on behalf of respondent number
1.
1 and raise for some time to file Wakalatnama. How many respondents are there?
There are 5 respondents, Lordship. Lordship has taken steps on all these respondents.
So only one is appearing.
One is appearing, Lordship.
What about the rest of the?
The rest we have taken steps, but service is yet to complete, Lordship. And return of services has not been
Okay.
marked. So Lordship may let it come after 2 weeks, Lordship.
Some time to obtain to file Wakalatnama and to end the affidavit in opposition if required, if necessary. Stuff. The service upon the other respondents are still awaited. In view of the above, list is matter after
2 weeks, Lordship.
2 weeks.
Lordship, similarly, in item 9, 10, 11, 12, and 12, they are similar matters.
9 also you are appearing.
My lord.
9, 10 also.
My lord.
9,
Okay.
10, 11.
Similar order there.
Lordship, in fact, these all these contempts are arising out of a common judgment.
Yes.
Passed in.
Okay. So up to 12.
Lordship, up to 12.
Okay.
Same, Lordship, same. In fact, Lordship, there's one more petition missed out, Lordship, so it can be listed together.
It was supposed to be listed along with this.
Yes, Lordship. It's a
Not been
COP
listed.
27.
Okay.
COP 27, Lordship.
7.
27 of 2024.
27, okay.
COP, contempt petition.
But then that is not with us today.
Please, Lordship, pardon, Lordship.
That 27 is not before
Not
us.
today, but Lordship, my prayer is that let the COP 27 be also listed with all these matters, along with all these matters.
Then to be listed together.
Lordship, together, since they're the analogous matters.
Okay, list is okay. List is matter after 2 weeks. Along with COP 27, COPC 27, 2024.
Yes, Lordship.
Okay.
COP 22, 23, 24, 25, 26, and 27, they are all analogous matters.
Okay.
It should be taken together, Lordship. Club together.
It has to be clubbed together.
Lordship.
All the respondents are also same.
Yes, Lordship.
Okay.
Response same. Matter, the issue is also same, Lordship.
Okay, list these matter, along with COP 27 also. After 2 weeks.
Lordship.
Okay. 2 weeks or?
2 weeks, Lordship.
Okay.
Since the other respondents are yet to appear, Lordship.
Okay.
For orders, item numbers 13 and 14.
May I please, Your Lordship?
Yes.
Lordship, I'm for the respondent claimant number 1.
And
The
you're
applicant-
claiming number 1.
Lordship.
You have any objection?
Lordship, I have to file. Otherwise also, Lordship, by order dated 24/9/24, the appellant was directed to take fresh steps upon the respondent to entry.
This is similar to the other one.
No, Lordship,
Oh,
this is,
different.
yes, Lordship. But
Order
it's
dated
24/9/24, Lordship. The appellant was directed to take fresh steps upon to entry, that is honor driver, Lordship. But it seems that the appellant is absent.
not yet taking steps. Okay, return service still awaited. They have taken steps, it appears. On 26/9. Okay, no one appears on behalf of the applicant on call. How, why? Mr. Empty Wapam, Lara Council for the respondent number 1 claimant. He is present. Staff. The office note dated. As per the office note dated 26/9/2024, the service upon the respondent number 2 and 3 is still awaited. In view of the above, least this matter after 2 weeks.
Lordship,
Okay.
highly obliged, Lordship.
For hearing, item number 19.
This is 19.
Yes,
Make
Your Lordship,
appeal.
19, Your Lordship.
The appellant is present?
Yes, Your Lordship. They are present.
Okay, and then who are the respondent?
Your Lordship, I am paying for 2 and 3, Your Lordship.
2 and 3.
The
How many
instruments.
respondents are there?
3 response, Your Lordship.
And
Respondent number 1 is the owner of the truck, Your Lordship.
Owner of
Owner
the
of the
truck.
truck, Your Lordship.
What is the challenge about?
Lordship, they are challenging the judgment on order of the MSCT case.
So it is only against the respondent number 2 and 3.
Yes, Your
The attendance of the respondent number 1 is not required.
The learned member of the tribunal
Hmm.
passed the order against respondent 1 and 2.
1
That
and
is-
2.
That is the owner of the truck involved in the accident.
Hmm.
So respondent number 3 and 4 were exonerated from the liabilities. That is why the claimant, I'm appealing for the claimant, I'm challenging the award, that the award should have been directed against all the respondents jointly and severally, not to exclude anyone else.
You are concerned with your award only, compensation.
Yes, but I have a title to give from the defendants jointly and severally, not to point out the particular respondent. That is the case. I'm not supposed to give the award from the owner alone.
You are for the claimant.
Yes, I am for the claimant.
You have not yet received the compensation. What is the amount passed?
Amount awarded is.
It is to be paid by the, you're appearing
No,
on
Your
behalf of
Lordship,
the
here, direction was given to the respondent number 1, Your Lordship.
One is,
The owner of the truck, Your Lordship.
okay, not the insurance.
The insurance was also given, Your Lordship. Your Lordship, page 41, Your Lordship, of the appeal, the
Just a minute.
order is
Page?
reflected. 41, Your Lordship.
Compensation was awarded, but the liability was fastened.
41 is,
Your Lordship, the
this is
first
operation
paragraph-
portion of the,
Yes, Your Lordship, the
operative portion of
operative
the-
portion, Your Lordship.
okay, let us see.
That, Your
The
Lordship, the-
respondent number 1,
yes, Your Lordship.
owner of the vehicle shall pay the awarded amount. Okay. The insurance is directed to pay only 2 lakhs to the respondent, claimant number 1.
Yes, your lordship,
And
this
then the rest of the amount is
by the
paid by the respondent.
truck driver, truck owner, your lordship. Your lordship, here the
Okay.
direction was given, keeping in mind that the passenger, that this is was the previous passenger, your lordship, in a goods truck, your lordship. As such, it does not covers under the policy led on by the insurance company, your lordship.
Lordship, I am appealing for the claimant's appellate.
No, if
So the claimant's appellate
the
will
respondent
have.
number 1 is truck owner.
Yes, your lordship, truck
If
owner,
the-
your lordship.
Whether the owner of the truck
Owner of the truck is
has paid you
ex
or not?
parte. Ex parte before this court.
Ex parte.
Yes.
Whether
It was substituted notice was issued by publication in the Assam Tribune. Gauhati Press, Assam Tribune. But
So the respondent number 1 never appeared.
yes, the respondent number 1 contested before the tribunal, but leaked no evidence. So it is almost admitted. Just filing written statement is
No,
not.
respondent number 1 participated the trial before the tribunal
Yes, through counsel.
through counsel.
Yes.
Then why you are saying ex parte?
Before this honorable court, respondent 1 is ex parte.
Okay, ex parte before this.
Yes.
Then respondent 1 should have come before.
That is why substituted notice was published in the newspaper, Assam Tribune.
No. Whether the respondent 1 is ready to pay the compensation.
No. When he is ex parte, how can it be presumed that he is ready to pay?
What are you submitting? You say that he participated in a trial before the tribunal.
Only through counsel. He does not appear in the.
Maybe through counsel, but then counsel appeared on his behalf only.
Yes.
That is, he has participated. That means
This issue I will enlighten before your lordship, because the case is not yet opened. My case is not yet opened. Whether I have the locus standi to challenge the award or not, that may be heard, because there are numbers of decided cases. Because before the tribunal, my prayer was.
Now the respondent number 1 has the respondent number 1 refused to pay the compensation passed by the land tribunal.
No, respondent number 1, he is ex parte. That is why he.
You say again participated. How it is ex parte? Where is? Can you see where it is?
No, lordship may say to clear this point, whether the claimant can challenge the award.
No, let
us against the owner of the vehicle.
Yes, that is second question. Let us come to the first question. Whether the respondent number 1 has participated in before the tribunal?
Through counsel, because there was no effective.
But then counsel was authorized by him only. Counsel was authorized by him.
That is why when the respondent does not appear before the court and adduce evidence, it is not contested. Just filing written statement does not mean that it is contested, because it is a trial. It is not a matter to be decided by affidavit. It was a trial matter. Witnesses are to be examined to prove the issue framed, but respondent number 1 never appeared before the court and adduced evidence. That is the case. It is almost ex parte. When no evidence is adduced, when the party never physically appeared before the court and given a statement in support of the defense, written statement, then how can it be said that he is contested?
Now, how you are agree by that?
I am agree.
Whether the respondent number 1 refused to pay the compensation directed by the tribunal?
When respondent number 1 is the ex party, how can I say that he declined to pay? I can neither say he agrees to pay, nor I can say that he is willing to pay, because he is ex parte. It is a matter of ex parte case.
After the order, after the compensation or the award.
Now I want to enlighten this position.
Just a minute.
I want to enlighten this position by a latest judgment of the Honorable Supreme Court.
No, wait,
It
wait,
is-
wait, let us clear the fact first. Thereafter, let us come to the Supreme
Yes.
Court.
The points your
Now,
lordship raised
now,
before me.
Wait,
I-
wait, you just listen and then try to understand what I want, what the
Yes,
court
yes.
want to know first.
Very much.
Court want to know if the respondent has participated earlier. According to you, the judgment was ex parte. Is there anywhere in the judgment mentioned that it has proceeded ex parte against the respondent number 1?
Before the tribunal,
Before the
there is
tribunal?
no specific order that it was an ex parte proceeding.
Then,
But at this stage, before this Honorable Court,
no, let us not come here first, huh? And then, okay, the order was passed, you do not know. But then after the order was passed, the judgment on the award was passed, whether you have given the copy of the award.
no.
To
When he never appears before the court, how the judgment copy shall be delivered to him? The question of service of the copy of the judgment and award to respondent number 1 is absolutely out of question.
How?
Because he never contested the claim.
Now,
That is the position. That is the difficult
but then
position.
but then the tribunal has directed him to pay compensation to you. Whether you have given a copy or forwarded
No, I have not given.
Why you have
Because
not?
I could not locate him. He is out of place. His residence is described as Titoba. It is a small town in Jorat district in Assam. He is given Titoba. The police is unable to find it out. His address is Pukas.
You have
That
not,
is why- that
you
is
have
why.
not even tried to serve a copy of the judgment in order to the respondent number 1 for compliance. You have never tried also.
Because the council was there. He appointed the council, but he never contested the claim. That is the case.
What are you submitting?
Hmm.
Council was there.
Let me see.
Then have you given a copy to the council and asked him to give it to the respondent number 1 to comply with the order and correction?
It is neither
Unless
my,
it is tried, then how you are agree by the order?
yes, with the, I agree for that. That is a legal point.
The
That
Senate
legal point
tribunal,
is
after appreciating
verified.
appreciating the evidences found, and then only pass an order directing the respondent number 1 to
Yes.
pay
Look,
that
what
amount. And
your lordship raised the question that is to be answered by a judgment of the Honorable Supreme Court. It is reported in 2024 ACJ
but then
881.
the basic
Yes,
thing,
basic law. This is the basic law of
what
the
it says, what it says.
liabilities.
Please read it.
Lordship, you have a copy of it. This is exactly like my case. Whether I have a locus standing to challenge it or not.
I have not yet asked the locus. I am
That is why.
asking you the basic step have you taken? Wanted to know. Yes.
In a road accident.
Where page?
Kindly turn to the next page.
This is
2024
which one you are referring?
ACJ 881.
2000?
2024 ACJ Accident Claims Tribunal.
Okay.
Page 881.
Okay.
Then coming to the next page, page 282. Judgment.
Yes.
Para 1, leave granted. Para 2, in a road accident that occurred on 16/7/2005, Mohinder Kumar sustained injuries and succumbed to the same. A claim petition was filed. A claim petition was filed before the Motor Accident Claims Tribunal, hereinafter referred to as the Tribunal, for the sake of convenience. The said claim petition was contested by the respondent insurance company as well as the owner of the offending vehicle, like my case. Because before the tribunal, there was a contest by filing written statement. By award dated 31/8/2011, a sum of rupees so-and-so, along with interest rate of such so-and-so person per annum was awarded by the tribunal, directing the respondent owner of the vehicle to deposit the said amount while exonerating the respondent insurance company. Exactly like my case, this is. Being aggrieved, the claimant questioned the compensation awarded and exoneration of the respondent insurance company by filing an appeal before the High Court in first appeal from orders number 448 of 2011. The High Court wiped its judgment and order dated 17/6/2016, disposed of the appeal by raising the rate of interest to 7.5% and holding that the insured is settled with the liability and directing the insured to deposit the entire compensation amount along with up-to-date interest within the period of 8 weeks from the date of the judgment. Paragraph 4. Being agreed with the judgment and order dated 17/6/2016, the insurance company approached this court by filing a special petition billing number CC number 21521 of 2016, which was dismissed as withdrawn with liberty to the insurance company to approach the High Court by filing a review petition. The insurance company then filed a review petition against the judgment and order dated so-and-so, which was allowed by way of passing the injunction judgment and order dated 21/11/2091, whereby though the rate of interest 7.5% was affirmed, the insurance company was totally exonerated of its liability. Paragraph 5. Being aggrieved by the order of the High Court, the claimants have preferred this appeal. Exactly like me, I am challenging the exoneration of the insurance company. Exactly this case. We have heard the legal counsel for the claimants, legal counsel for the respondent insurance company, and legal counsel for the owner, and peruse the materials and report. In substance, the contention of the legal counsel for the appellant is with regard to the exoneration of the respondent insurance company and fastening the entire liability on the owner of the vehicle. Exactly like my case. The insurance company was wholly exonerated. Nothing was asked to pay. The entire liability has been directed to be paid by the owner of the vehicle like this. Para 8, in the circumstances, we modify the judgment and award passed by the High Court as well as the claims tribunal by directing the insurance company to pay the compensation awarded by the High Court, being rupees so-and-so with interest in the rate of so-and-so percent with effect on the date of claim petition till realization. However, the said payment shall be made within a period of 6 weeks from today. Para 9. Liberty is reserved to the respondent insurance company to seek recovery of the said amount from the respondent owner. Although the respondent owner had not assiled the judgment and award of the tribunal and fastening liability only on the owner and exonerating the insurance company, nevertheless, in the interest of justice, liberty is reserved to the respondent owner to take all contentions available to him, including offending driver possessing a valid and effective driver license to drive the offending vehicle on the date of the accident in the proceeding to be initiated for recovery of the aforesaid amount. The aforesaid direction are being issued in exercise of the powers under Article 142 of the Constitution of India, having regard to the facts and circumstances of the case, order accordingly, they will allow and dispose of it. Exactly like my case. In this reported case also.
This is
This year's case. This judgment is dated 2/8/2023. It was passed last year in August, but reported only this year in ACJ 2024 ACJ 883. It is passed by the Honorable Supreme Court. Here, in this reported case also, the insurance company was totally exonerated. That is why the claimant preferred an appeal.
It appears that insurance company has also been directed to pay rupees 2 lakhs plus something to.
No, in my case, nothing was up to pay.
Number 1.
No, that is another case because it is a common judgment.
Lordship.
The judgment,
Another case.
the judgment I appealed is a common judgment. ABC case number 15 of 2016, 16 and 16 of 2000, two cases, analogous cases. So I am
Analogous
agree.
cases have been disposed of by the
Common judgment.
common judgment.
Yes. So the other case
But
no
that,
appear.
that the accident arises out of the same accident.
Yes, very much. Out of the same accident.
In the another case, it was directed to the insurance.
Yes, in one of the cases, it was directed to be paid by insurance company. You have already paid and realized the amount. The other case came up for appeal before this court.
Yes.
There is nothing to hesitate. The law is very clear.
The
Lordship, during the proceeding, your Lordship, four issues were framed, your Lordship.
yes.
If your Lordship would come to page 33, your Lordship. Page 23, your Lordship. Of the appeal, your Lordship.
Yes. What is that?
Part 9, your Lordship.
Hmm.
If I may be allowed to read, your Lordship. Lordship, on the basis of the pleading, your Lordship, the following issues were framed for adjudication. Serial number 1, your Lordship. Under what facts and circumstances the deceased were involved in the accident dated 17/02/2014 involving truck number AS03AC/5021. Second issue was, your Lordship, on the facts and circumstances of the case, whether the principle of res ipsa loquitur is applicable and reckless and negligence driving of the truck by the deceased driver can be held. Third issue, your Lordship, whether the vehicle involved in the accident was having all valid effective documents, including driving license of its driver at the time of incident. And the fourth issue was, your Lordship, whether the claimant are entitled for any compensation. If so, what amount and who are liable, your Lordship. Lordship, I'll be reflecting on only the issue number 1 into your Lordship. Lordship, if your Lordship will come to page 33, your Lordship. The findings and decisions of the framing, your Lordship.
Yes.
Lordship, if your Lordship would come.
You are concerned with issue number 1 and 2.
1 and 4, your Lordship.
1 and?
1 and 4, your Lordship. It is clearly reflected as to
Only
why.
1 and 4.
1 and 4, your Lordship. It is clearly reflected there, your Lordship, as to why compensation was directed. The court have directed to give compensation to respondent number 1 instead of the insurance company, your Lordship. Lordship will come to the last line, your Lordship. Thus, as per your Lordship, last line, your Lordship.
Last line.
Yes, your Lordship. Page 33, your Lordship.
33, last line.
Last line. Thus, as per that, few words were reflected here, your Lordship. Lordship here, your Lordship. The last.
Yes, that's okay.
Yes, your Lordship.
Same last.
Yes, your Lordship. Thus, as per the facts and circumstances of the case, late Sentilamba was traveling in a truck as a gratuitous passenger. Since the truck involved in the accident was a good carrier vehicle, which covers use of vehicle as per the terms and conditions laid down by the policy coverage, and as such, the liability of the insurance company is determined only on the basis of the terms and conditions, your Lordship. Lordship, this is very important, your Lordship. As per the terms and conditions of the policy laid down, your Lordship, the insurance company, they are liable, your Lordship. And your Lordship, if your Lordship would come.
As per the terms and condition of the.
Yes, your Lordship.
Insurance is liable.
Insurance policy, your Lordship, of the truck, your Lordship.
Who is liable?
The insurance company, your Lordship. That's as per that policy, they are liable as per the policy, your Lordship. Your Lordship, what has happened is in this matter is that this was a gratuitous passenger, your Lordship, meaning he was not the employee of the good carriage company. And as per the facts in the appeal.
He should not have boarded.
Yes,
in
he
the
should
truck
not have
itself.
boarded, your Lordship. And as per that direction, issues were framed and direction was given, your Lordship. And if your Lordship would come to page number 41, your Lordship. Page 99, your Lordship, of the appeal, your Lordship.
Lordship, kindly bear with me. Since I am the appellant, if I am hurt, it shall be easy to respond by them, because respondent is to be heard first. That is not, it won't be blurred. Since I am the appellant, I may be heard, I will enlighten my case, the respondent shall reply. The respondent shall reply what I say.
Yes.
That is the procedure. Well, not that I should reply what the respondent says.
No, yeah, seeking, you have already read the judgment also.
That is why the grounds of challenge I have to show you. Otherwise, how the court shall take up the matter when I am not heard? Only when the respondent is heard.
Under what circumstances this order was passed?
That is why I want to enlighten before your lordship.
Please,
Yes,
you text it.
yes. Kindly see.
That is why he was explaining. Yeah.
Kindly see page 33, internal page 33.
Yes.
That is the findings. Para 17 of the impugned judgment and award. Paragraph 17.
Yes.
Kindly see. Shall I read?
Yes, please.
Paragraph number 17, findings and decision. Issue number 1. Under what facts and circumstances the deceased persons were involved in the accident dated 17/2/2024 involving truck number so and so, so and so. Then comes the evidence of PW's here and above has proved that in MEC case number 15 of 2015, that is the present case, MEC case number 15 of 2015, late Cindy Limba was the owner of some of the goods carried in the truck on payment of charges, rupees 2,500, and he was accompanying the goods carried in the truck, which was involved in the accident. The deceased person in MEC case number 16 of 2015, Srimati So-and-so, was a pedestrian who was knocked down by the offending truck. The final report of the IO dated 14/10/2014, which is Exhibit B5 in MEC case number 15 of 2015, and Exhibit B1 in MEC case number 16 of 2015, has stated that one vehicle truck bearing number so-and-so had met with an accident and fell down below the road into a deep gorge while proceeding towards Mokokchung is in Nagaland, from Jorat, that is in Assam, being driven by late Alimuddin. As a result of the accident, 5 persons, including the driver, died on the spot. It is stated that report of the 5 persons who died are Alimuddin, Sandi Limba, Monmaya, Tara, and Normaya. So 5 persons died means three of them were pedestrians. 3 pedestrians were knocked down by the truck, and the truck fell down below the road, causing the accident.
3 of them were?
Lordship?
3 of them were, you said?
3 of them were walking on the road.
Okay.
Yes, they were at night. It was mid at night, 12:30 a.m.
Which of them?
So
One
here,
serial number?
Monmaya, Tara, and Normaya, all these ladies were walking on the road. Their vehicle is broke down. That is why they were walking on the road proceeding for H Junction. H Junction is a small substation where transport may be available. That is why in the dead of the night, they were proceeding to H Junction, which was about 1 kilometer away from the...
They were proceeding to?
They were proceeding to a particular place called X Junction, X.
Okay.
Junction.
Okay, junction.
So in that junction, people are residing. It is.
Who is this Alimuddin?
Alimuddin is the driver of the truck.
And who is this
Santi Lapa is the present deceased person.
He was also traveling.
Yeah, he was traveling in a truck along with his coats carried in the truck on payment of rupees 2,500 freight charges. That is the case. Now
what happened to the...
All the other 4 claimants are, three claimants are settled. 3 means Monmaya, Tara, and Normaya.
They have received the... from the...
Yes.
Insurance company.
2 of them were settled out of court. Mutual settlement. 2 claim cases were settled outside the court, and 1 was disposed of by this command judgment.
Okay.
1 means...
Which one?
Tara and number 4 and 5 were settled outside the court. The mutual settlement.
And just a minute. So in this case, Monmaya is there.
Yeah, Monmaya is there. That is MEC case number 16. 16 of 2015. 16 of 2015. Can you see?
16 is MSCD case. MSC case number 16 is for Monmaya.
Yes, Your Lordship. 16, Lordship.
Not Monmaya, Normaya. Normaya, I mean.
Normaya.
Normaya.
Just a minute. Where is it?
Normaya is serial number 5. That case has been disposed of by this command judgment.
Just a
Kindly,
minute.
kindly see the
Normaya,
poster.
not Monmaya. Normaya.
Yes, Normaya.
Okay, and then the case of Monmaya and Tara
And
was
then
settled outside,
another, and
outside
then
the court.
another Monmaya. One is Monmaya, one is Tara, and one is Normaya. This was settled. Settled means one was decided by MSCD and already paid by this judgment. 2 lakh something was awarded, and then already.
Just a minute, huh? You just reply my question. Huh? Monmaya and Tara, case of Monmaya and Tara was settled outside the court.
Yes, yes, very
Okay.
much. That is correct.
So Normaya is MSC case number 16.
Yes, 16 of
Normaya,
2015.
she has been awarded how much amount you said? 4 lakhs.
Yeah, two point.
Or 2 point something. Okay. What about the Alimuddin and Alimuddin?
Alimuddin, we have no idea. No, he never comes before the tribunal. He's legal here. He's a dead driver. He was the driver and dead. So no claim.
No claim made.
No claim.
Okay. So this Monmaya and Tara, do you have any record of their settlement? How much they were paid?
No. The settlement was, I have no idea about.
No idea.
But copy of the claim petition I have for this.
Okay, they also came to the
Yeah,
but then it was settled.
The
Subsequently, it was
the legal hearings also
Okay.
come before the court.
Okay, but then subsequently it was settled outside.
Yes.
In the local
yes,
Adalat property. Okay, so how much they were paid, you do not know.
Because they were only
What is their claim?
housewife, no?
Yes. Oh, housewife. But in the case of Normaya, you have paid.
Yes, Your Lordship.
In the case of Normaya, you have paid.
Yes, Your Lordship. And in the
Involved with the same vehicle.
Yes, Your Lordship. Lordship, and the instant appeal has been filed by the claimants for
So
MSC.
according to you, the settlement, the President Clement
Yes, Your Lordship.
has no right to sit in the vehicle.
Yes, Your Lordship.
Had no right.
Yes, Your Lordship. And it's clear as per the policy of Lordship, insurance policy. It's annexed in the appeal as well, Your Lordship.
Okay, so the
And Your Lordship.
okay.
Lordship, there's
Otherwise, the insurance company, insurance policy, driving license,
yes, Your
everything
Lordship.
was fine.
Everything was fine, Your Lordship.
Okay.
But they have violated the policy, Your Lordship.
But then it should have been directed against the insurance company only.
No, Your Lordship.
No, directed against, even if it was directed against the owner.
Against the owner, Your Lordship.
Owner.
Yes,
And then the insurance should have been directed to pay.
Your Lordship, no, since there was
recover from the owner.
Yes, Your Lordship, since there was a clear violation of the policy, Your Lordship, insurance policy, Your Lordship, the Honorable Tribunal, MSC.
Did the owner contest the case?
No, Your Lordship, the owner, they have not contested.
Filed directed instrument, but accused no evidence. He abstained coming to the court except the counsel. Counsel also lost contact with the
Okay.
respondent one, owner of the truck. Counsel also lost contact. That is why he is not appearing here also.
Your Lordship, the actually
Because these are nomadic people.
So then the
These people are South Indian people. They were residing in Jitaba, a small township, nah. But after this accident,
he left.
yes, one after another, all of them gone. That is the problem. Even the police are unable to trace out.
Lordship, response number 1 should have contested, Your Lordship. I can say about Your Lordship instead of declaiming, Your Lordship. Since the direction was given to the response number 1, Your Lordship, the honor to pay the award, Your Lordship.
Now you see the person has lost his life.
Yes, Your Lordship.
And then the direction to the person who is no longer.
No, it was to the
in a
truck
place.
owner, Your Lordship.
No, the truck owner.
Yes, Your Lordship.
Who is no longer participating in the trial also.
Lordship.
Then it means amount to non-payment.
Yes, Your Lordship. Lordship, but
Because directing the person who is no more or no longer in the place, and then knowing that it will not be executed, this was passed by which court?
Lordship,
Which
MSC
is
So it's
urban-
passed by
urban
the
where?
Principal District Incident Judge, who is the ex-official member of the MSC.
No, just a minute.
MSCD Dimapur, Your Lordship.
Dimapur only.
Yes.
Yes, Your Lordship.
So the direction, the accident took place where?
The accident took place in somewhere in Marani Mokokchung Road. Mokokchung is a district within Nagaland, and
Yes.
Marani is a railway station junction, railway junction down within the district of Jorat in Assam. So this is the commercial road.
Okay, the owner stays in Assam.
Owner is staying in Jorat district.
What about the
in
vehicle?
Pitabar.
What about any criminal case was also recorded?
The criminal case was
But
dropped,
then since
dropped
the
down
driver-
because
Since the driver is no more.
driver is no more. That is why the police is not registered any regular case.
Okay,
UT case, that is called unnatural death case.
but then whether the police had investigated,
Yes, the police is given their report.
finding a report, final report must have submitted
Yes,
final
yes.
report. What the police says about the present claimant, he was traveling.
The police, it is reportedly the police got briefing from the handyman of the truck.
And even if the track was still alive.
Handyman of the truck was alive because the claimant, the deceased wife is claimant number one. So claimant number one was trying to contact his deceased husband over mobile phone. The whole night and the whole morning. The accident took place 12:30 a.m. on 17 February 2014. Then he could not contact. Contact was lost. Till 9:30 contact was there, 9:30 p.m. on 16 February. Then by the midst of the night, contact lost. But the following day, in the noon time, around 12:30 to 1 p.m., mobile phone was picked up.
By handyman.
Yes, but
He was the only person
yes.
alive. He was the only person alive.
Yeah, he is the sole person
How many
alive.
persons were traveling at that time?
Three of them.
Three of them. Okay.
Three of them were traveling, the driver, handyman, and the owner of the boat. This is person.
No, driver, handyman, and
Driver, handyman, and the deceased.
okay, this is
Who was the owner of the boat? Some boats carried in the truck.
owner of the
Owner of the boats. Because it is a boats carrying commercial truck.
owner of the
Owner of the boats.
goods.
Goods.
Okay.
Goods carried in the truck. He loaded some.
Okay. He was a businessman.
Now his wife was running a wayside amenity center. Hotel,
Okay.
hotel come restaurant.
Whether this has come in the evidence?
Yes, very much. It is in evidence. The disease was a cattle attendant, regular
one
service.
minute. In the as per the policy, how many persons are covered?
2%, Your Lordship.
Only
No,
two.
no, three.
Yeah.
It is only three. It is in the policy.
Lordship, it is clear that as per the interpretation, Your Lordship.
Kindly see exhibit A1. Kindly see. Exhibit A1. That is the exhibit of the insurance company.
Only three persons were traveling.
Yes, 3 persons are covered.
Exhibit.
Your Lordship, but if I may, Your Lordship, this was neither the employee or the quality of the person.
His good was carrying in that.
No, Your Lordship, he have boarded the truck, Your Lordship, with his goods, Your Lordship, paying an amount of 2,000 something to the driver, Your Lordship.
She paid.
No, paying to the driver, Your Lordship. And it was between the driver and the so-called deceased. Your Lordship.
The truck is a commercial truck.
So
It
where
is
is
not
the
a
policy you
truck.
want to show me? Where is the policy?
Kindly see exhibit A.
Have you annexed or? to the-
Because I could not get this exhibits now. I brought only a premium chart.
Just a minute.
With my claim application, I have filed only premium chart. So whereas the insurance company and the owner of the boat filed copy of the police system com certificate.
Exhibit
Exhibit A.
A.
For the insurance company.
Can you read it once?
So here, the seating capacity, the insured seating capacity, including driver is 3. It is clearly marked in the insurance policy. 3. Seating capacity of the insured, it is 3%, inclusive of driver.
Just a minute, where it is?
Lordship, the page 99 of the appeal, Your Lordship.
99 of?
It's in the appeal as well, Your Lordship.
In the appeal, it is
Yes,
there.
yes. Sure.
You have not finished me, that is the
In the
The
appeal,
appeal was filed by you only?
yes, Your Lordship, in the appeal, Your Lordship. The
That is
MS Chula insurance come policy, Your
The policy covers 3%.
Page 90?
99, Your Lordship.
99.
Yes, Your Lordship. Your Lordship got it, Your Lordship.
Yes.
Lordship here, the Landed Council is referring to the total seat capacity, including driver, Your Lordship.
Okay, where do I find
Your Lordship.
seat capacity?
It is also right inside in the upper portion of the page, upper portion of the exhibit.
Business or professional individual?
Below A, remember A is 03,
Okay.
AC 5 below this.
Below that?
Yes, Your
Yes.
Lordship. Your Lordship, if you come,
Total seating capacity, including very small letters.
Body,
total seat capacity, including driver, Your Lordship.
Total seating capacity, including driver, 3.
body,
Got it, Your Lordship.
just a minute, carrying capacity.
Yes, Your Lordship.
Passenger carrying capacity 2.
Yes, Your Lordship.
Dri-
Licensed
driver-
passenger.
Driver and others 1. Or what? Which one?
Your Lordship, there is
Okay,
Your Lordship.
total seating capacity.
Your Lordship.
Yes, got it.
Yes, Your
Wait, including driver 3.
Yes, Your Lordship. That's the total capacity, Your Lordship. And if Your Lordship would come to the left side of the same table, Your Lordship.
Yes.
Left side, Your Lordship, of the same column, Your Lordship.
Yes.
Licensed passenger carrying capacity, Your Lordship. 2, Your Lordship.
2.
Yes, Your Lordship. Lordship, that's the licensed
Carrying
passenger capacity, Your Lordship. And the total
Passenger
seat.
carrying capacity is 2. And
Yes, Your
the-
Lordship.
the-
2 plus
the
1. This is driver.
driver and others 1.
Driver, handyman, and owner of boats, normally.
Total seating capacity, Your Lordship. That's the description of the truck, Your Lordship, not the license carrying capacity, Your Lordship, of the passenger, Your Lordship.
Lordship, it is a LPG truck. It is a 14th owner vehicle. So the keeping is vast enough, but the manufacturer has provided only for 3 occupants. It is a LPG truck.
No, this is, see, license
License
passenger
carrying
capacity 2.
It's 2, Your Lordship.
And driver another 1. So that is total 3.
Yes, already given 3. You have undertaken 3.
And then total total seating capacity including driver 3.
Your Lordship, license
Because it includes 2 plus 1 driver.
2 plus 1, Your Lordship,
Yes.
but
Then
license,
1 is entitled.
Your Lordship, license passenger carrying capacity 2, Your Lordship.
License passenger
Carrying
carrying
capacity
capacity
2. Your Lordship, that's the capacity
carrying
carrying goods,
capacity.
Your Lordship.
That's
That's the
carrying capacity.
handyman and the driver, Your Lordship.
No, driver is separate. Driver and other 1.
No, Your Lordship, that's the total capacity, Your Lordship.
No, total is somewhere this side again. Total seating including driver 3.
Lordship,
Wait.
Lordship, total capacity meaning that's a description of the car, Your Lordship.
So including these 2 and 1, that is total 3.
yes.
Your Lordship, but that's for the employee, Your Lordship, not employee of the
Where
owner, Your
it is
Lordship.
written?
If Your Lordship would come to the liability, Your Lordship, limitation as to use, Your Lordship.
Where?
The third table, Your Lordship.
Hmm?
Third table, Your Lordship. Lordship.
2, 3, third table.
Third table, Your Lordship.
Below.
That's the final table, Your Lordship. Limitation as to use, Your Lordship. Dear Your Lordship, the policy have clearly stated what's the policy, Your Lordship. If I may be allowed to read it, Your Lordship.
Please.
Lordship, the policy covers use of only under a permitted within the meaning of the Motor Vehicle Act 1988.
No, where do we find that?
Lordship, here, Your Lordship,
Third table.
just the third table, Your Lordship. 1, 2, 3.
Oh, that is
The
third
first one,
table.
Your Lordship.
Okay, that is not third table. 1, 2, 5.
Yes, Your
It's a
Lordship.
fifth table. Limitation is.
Limitation as to
That is
this, Your
fifth
Lordship.
table. Fifth.
Yes. Lordship is clearly stated that, if I may be allowed to read it.
Yes,
Your
please.
Lordship. The policy covers use of only only a permit within the meaning of the Motor Vehicle Act 1988, falling under the subsector 3 of section 66 of the Vehicle Act 1988. The policy covers use of vehicles for purposes other than, Your Lordship, organized racing, number B, use while driving a trailer, except the towing other than for reward for any disabled mechanical propelled vehicle. Number C, Your Lordship, pacemaking. Number D, reliability trail. Number E, speed testing. Number F, use of carrying passenger in the vehicle, except employees not exceeding the number of permit in the registration documents and coming under the purview of the Workmen's Compensation Act 1923, Your Lordship.
Except employee.
The number, yes, Your
Not
Lordship.
exceeding the numbers of permitted.
Yes, Your Lordship.
Permitted in the registration document.
And
The
coming-
permitted in the registration document is a tree.
Yes, Your Lordship.
Yes,
Employee,
clear.
Your Lordship, employee, Your Lordship. It is clear that the deceased or the any person who have boarded the truck, Your Lordship, who is not an employee, does not come under that act, under the
No,
policy, Your Lordship.
No, except employee.
Except employee, Your Lordship.
If it is employee,
Yes, Your
he
Lordship.
will be entitled.
Yes,
only.
Your Lordship.
But then not exceeding the number
Yes, Your Lordship.
permitted in the registration. But the number permitted in the registration is 3.
Your Lordship, but that's not an
2 plus
employee.
1. Huh?
2 plus 1 is clear, Your Lordship, but the person who have bought it is not an employee, Your Lordship.
No.
He was not given.
No, except the employee, in any case, employee will be entitled.
Yes, Your Lordship.
But then here it says that except employee,
Yes, except employee.
not exceeding the
Lordship,
number
the-
permitted in the registration
Yes, Your
document.
Lordship. Yes, it's.
So it should, in any case, it should not exceed 3.
Your Lordship, it should be read conjointly, Your Lordship.
Yes.
Except employees, Your Lordship.
Hmm.
Not exceeding the number of permit in the registration documents, Your Lordship. Meaning, Your Lordship, in the employee is more than 3, Your Lordship. The policy will cover only 2, Your Lordship. It is clear, Your Lordship, from there. And Your Lordship, if I may be allowed to make it clear that this was not an employee, Your Lordship. And as per the facts,
That is true. You're right. This is was not employed, but
Yes,
the
Your-
capacity of the truck was 3.
yes, Your Lordship,
And then
but
here also it says that except employee will be entitled in any
no,
case.
no, including the employee, Your Lordship, including the employee
Then the
except 3.
capacity is 3.
Yes, Your Lordship. Your Lordship, use for carrying passenger in vehicles, Your Lordship, it is also there, Your Lordship. It should be written joining, Your Lordship. And what has happened in this matter is that, as per the facts, Your Lordship, as per the facts, as per the findings of the Honorable Tribunal, Your Lordship, if I may be, issue number 44, for Your Lordship, page 34, Your Lordship. That's the operative part, Your Lordship.
Issue number 4. Page.
Yes, Your Lordship. Page 34, Your Lordship. Issue number 4. Your Lordship, page 36, Your Lordship. The issue number 4, Your Lordship.
Yes.
Lordship,
Whether the claimants are entitled.
yes, Your Lordship.
Hmm.
Para to Your Lordship, if I may,
Yes.
may be allowed to read it, Your Lordship, from the beginning, Your Lordship.
Hmm.
The claimants have stated that all the claimants in MSC 15, Your Lordship, which is the instant against the appeal, Your Lordship, are the legal representative and dependents of the deceased, being his wife and children, and thus they are entitled for compensation. Similarly, Your Lordship, that's for the other one. If Your Lordship would come to second part, Your Lordship. On the other hand, respondent number 2 and 3 have argued that the truck driver involved in the alleged accident was a good carrier vehicle, and the issued policy covers use of, as per the terms and conditions laid on by its policy, this is led Sentinel in MSC 15 was traveling in the offending driver as a gratuitous passenger, and as such, there is a clear violation of the terms and conditions of the insurance, and the company is not liable to pay any compensation to the claimant or to identify the owner of the vehicle. It is also further argued that the compensation should be just and reasonable. At the same time, it should be a bonanza or source of profit for the victim. The insurer further argues that in the present case, considering the facts and circumstances of the case, the indemnity cannot be invoked in as such as the vehicle involved in the alleged accident has not complied with the terms and conditions of the insurance company. Therefore, in the instance case, the indemnity cannot be extended in terms of the terms of insurance policy. As such, the insurance is not liable to pay any compensation to the claimant in MSC 15 of 2015.
So this is the fine.
And
This
if
is
your
the
lordship
finding
would
or
kind,
this is the finding.
yes, your lordship, and if your lordship would come to page 39, your lordship. 39, your lordship.
Lordship, if my case is heard,
Yes, just
it
wait,
will be,
wait, wait.
it will be
Just a
easy for
clarification.
respondent.
Just clarification.
Lordship.
Thereafter, you'll be heard. Don't worry. Just
All right.
certain facts, no? Certain facts
Yes.
before going
Okay.
through need
All right,
some
all right.
clarification first.
All right.
Okay.
Lordship, para 39, your lordship. Page 39, para the second para, your lordship. The vehicle truck bearing so-and-so, which was involved in the accident, was undoubtedly a good carrier vehicle, and the insurance policy covers a vehicle as per the terms and conditions laid down in its policy. The terms and conditions of the policy are clear and categorically, and it creates a specific bar on carrying any passenger except employees not exceeding the number permitted in the registration and thus and coming under the purview of the Workman Act, your lordship. Your lordship, further, according to the registration, Exhibit P6 in MSC 15 of 2015, the number of employee passenger permitted is 1, including the driver, your lordship. Lordship, this is
But then we have seen the insurance policy.
lordship is 1, your lordship. This is the observation made by the.
This is observation, but then the fact we have seen is 2 plus 1.
No, it's not
It's a
2
wrong
plus 1, your
observation.
lordship.
Hmm?
It's 2, your lordship. And as per the policy, total number of seats is 3, your lordship. I
Yes.
mean, that's total capacity of the seat in any car, your lordship. In
Let
the
us
truck.
read it again. Let us read it again.
The vehicle drug bearing number so-and-so, which was involved in the accident, was undoubtedly a goods carrier vehicle, and the insurance company covers use of vehicle as per the terms and conditions laid down by its policy. The terms and conditions of the insurance policy are very clear and categorically, and it creates a specific bar, lordship, on carrying of any passenger, except employees not exceeding the number permitted in the registration document and coming under the purview of the Workmen's Compensation Act 1923. According to the registration certificate so-and-so, the number of employee passenger permitted is 1, excluding driver, your lordship. The deceased late Sintilemba in MSC 15 of 2015 was therefore traveling in the offending driver as a gratuitous passenger, as there was a handyman with the driver, and as such there is clear violation. And your lordship, if I may be allowed to make it clear that this is your lordship, he boarded the truck, your lordship, when the truck was proceeding from Gauhati towards Mokchung, your lordship. Lordship, the truck was
Traveling from Gauhati side to Mokokchung.
Gauhati to Assam, your lordship. He boarded the
No. From Gauhati to
Mokchung towards Mokchung, your lordship.
It was traveling.
It was traveling, your lordship. And what has happened is that this is your lordship. He have stopped the truck and boarded the truck with Samkos, your lordship.
Okay.
Your lordship, that's all, your lordship.
Okay. Yes, please. Now.
Lordship, here, in the police procedure relied by the respondent,
So because the observation you have seen.
it is
yeah,
very
that's-
clear.
The observation made by the Learned Tribunal is that he has interpreted this as that except employees not exceeding the number permitted in the registration document and coming under the purview of the Workmen's Compensation. And number of employee permitted is 1, excluding driver.
Excluding
So
the
his interpretation is only
Yes, Lordship, here, the deceased cannot be treated as a passenger. The deceased is to be treated as the owner of goods, traveling in the vehicle along with the goods. That is the law. Because the owner of goods, the hire of the vehicle cannot be treated as a courteous passenger. Passenger means a passenger who is traveling in the truck without any connection.
Where do
So
we find that explanation?
the law shall come.
Because supposing in a truck where it is permitted 1+2, and then 15 persons have their goods loaded in the truck, and 15 persons are traveling, are the insurance liable?
1
With
plus
the
2.
insurance liable.
The driver and handyman are under Workmen Compensation Act. Because they are employees of the owner of the vehicle. Employees of the insured owner of the vehicle. So they are covered by Workmen Compensation Act 1953. Very clear under this Act policy. This is called Act only policy. This portion. This very portion. Of course, it is a B policy. It covers the value of the vehicle also. It is called comprehensive policy. B policy or comprehensive policy. But we are talking about the, so far as the present traveling is concerned, it is a third party insurance. Third party insurance covers the insured employees. That is the driver and handyman. They are within the definition of Workmen Compensation Act. Workmen means the driver as well as the handyman. They are not in a ministerial employment. They are workmen. That is why they are covered by Workmen Compensation Act, and under Section 147 of the Motor Vehicle Act, insurance issued under this section covers them. The other one is owner of the goods. Owner of the goods is a person who engages the truck for carrying his goods on payment of higher charges, freight charges. So this is what the person who loaded his goods in Mariani. Mariani is a commercial town, a small town. Railway junction is there. In the market, the vehicle stopped there. The vehicle was proceeding from Chorat towards Mokokchung. And halfway, the truck stopped, and then the deceased goods were loaded there. Some boxes of fruits, biscuits, vegetables, like that. So because he is having a wayside amenity center there in New Longchongpong, that is a cattle breeding farm, it is a wayside amenity resort. So there, the deceased family was running a...
Now explain this, according to the insurance company, it is 1+1, driver and the handyman only. Who is in
No.
So explain this.
Kindly see. Let us kindly see the insurance policy. Insurance, because we are going by the terms and conditions of the insurance policy. In the bottom portion, kindly see. Bottom column, bottommost box.
Yes.
In the bottommost box, it is clearly given. I/we hereby certify that the policy to which this certificate relates, as well as this certificate of insurance are issued in accordance with the provisions of Chapter 10 and Chapter 11 of the Motor Vehicles Act 1988. So what Chapter 10 says, Chapter 11 says, kindly see, the Railway Act 1988.
MSCP? MSCP, please.
So this policy was issued when all act was enforced. 1988 was amended in 2019 also. So there is a little changes in the section numbers because of the amendment brought by 2019 Amendment Act. So 1998.
This incident occurred in?
This incident
in the year?
Took place in 2014. But a new amendment was brought only in 2019 with effect from November 2019. So kindly see chapter 10 is the no fault liability.
Yes.
Now the chapter 10 covers the final award. Chapter 11.
Chapter 11.
Yes. He have issued the policy in accordance with the provisions of Chapter 10 and Chapter 11 of the Motor Vehicles Act. It is clearly divisible because this is compulsory insurance. The insurer is bound to insure it. Because this is under Act policy. Act policy means under the Motor Vehicle Act. In accordance with the provisions of Motor Vehicle Act, this policy has been issued. So kindly see, section 47. Section 47 is in chapter 11. This supports the it is a new act now. 1998. 1998, they did no work before 2019. Because this was issued before 2019.
It covers under old act.
Yes, under the old act as well as the new act. No changes in the new act. Only the section number has changed.
Section.
Right. Section number also not changed. Only the contents has been changed. Section 47, 147. Can you see section 147? Section 147 is under chapter 11.
What it says?
Section 147.
Yes, what it says.
Shall I read?
Yes.
Requirements of policy and limits of liability. Subsection 1. In order to comply with the
147.
Yes, 147.
Yes.
Subsection 1, 147, subsection 1. In order to comply with the provisions of this chapter, a policy of insurance must be a policy which, subclause A, is issued by a person who is an authorized insurer, and B, insures the person or classes of person is specified in the policy to the extent is specified in subsection 2. 1. Against clause I, against any liability which may be incurred by him in respect of death or bodily injury to any person, including owner of goods or his authorized representative carried in the motor vehicle, or damage to any property of a third party caused by or arising out of the use of the motor vehicle in a public place. 2. I2, against the death or bodily injury to any passenger of a transport vehicle except courteous passengers of a goods vehicle caused by or arising out of the use of the vehicle in a public place. So, subclause I clearly embraces the owner of goods. This is called statutory liability. It is not a tortious liability. It is a statutory liability. It is not a civil liability, I mean. It is not under the civil law, but it is under the statute. This is called statutory liability. The insurer is bound to insure those owner of goods carried in the vehicle. So the insurance policy was issued in accordance with this provision of section 147. So the insurer cannot escape the liability because the deceased person was the owner of goods traveling in the truck where the goods were loaded. Very clear. This, including owner of courts or his authorized representative, was brought into the statute book or incorporated into the statute by 1994 Amendment Act. This was incorporated under 1994 Amendment Act, which is continuing under 1999 Amendment also.
Have you gone through the provision?
No, Your
The
Lordship.
provision just read?
No, Your Lordship.
Just go through once and see it. Does it not cover? 147. I. With I, the including.
Lordship, this covers only a bit. Lordship, if Your Lordship would appreciate the fact that Your Lordship,
So
the
owners
truck,
of the goods also it covers.
yes, Your Lordship, owners of the goods is clear, Your Lordship. I have
Yes.
no objection to that, Your Lordship. But Your Lordship, the truck, Your Lordship, was a good carrier truck, Your Lordship. Not a passenger truck, Your Lordship.
No, passenger truck would be different.
Yes, Your Lordship, passenger
So
truck will be
this
different,
is
Your
not,
Lordship.
this perhaps is not talking about.
Passenger truck is covered by subclause I3. Yes,
Passenger
quite
is
different.
different.
This is we are
Passenger is
talking about I1.
Your Lordship, here the policy is clear, Your Lordship, and the observation made by the tribunal is also clear, Your Lordship, including the driver one, Your Lordship.
The passenger truck is covered by which you said? Passenger, I3?
Under the new act. PSP, public service vehicle, that is bus, minibus, omnibus, these are covered by subsection 2, subsection I2. Subsection I2, that is against the deed or bodily injury to any passenger of a transport vehicle except courteous passengers in a goods vehicle.
Goods vehicle.
Now, PSP, public service vehicle definition has been changed into transport vehicle only. Simple words, transport vehicle, by the new amendment definitions under the Motor Vehicles Act.
Now, according to you, this 147 B1 is talking about the truck.
Yes.
Goods truck.
Yes, goods carrying commercial truck. Not a private truck. Goods carrying private trucks, it is different because it is not for hire. It is not open to the public to hire, but commercial truck. Commercial truck, anybody can hire it, jointly or singly also. 2-3 person joint together may also hire, because all the costs are below that. It does not mean that a single person has to hire the truck, big truck. So meaning of owner of goods is also interpreted in the judgment of the division bench passed by the Honorable Al-Harad High Court in terms of Section 13 of the General Clauses Act.
Your Lordship, if Your Lordship would come to surplus to Your Lordship, against the death, Your Lordship, against the death of or bodily injury to passenger or transport vehicle, except gratuitous passenger of goods vehicle, Your Lordship. Goods vehicle, Your Lordship.
Where are you reading?
Lordship 147, Your Lordship. That
147?
B2, Your Lordship. Subclause B,
Against the date of,
bodily injury to any passenger of a transport vehicle.
no, it's a public vehicle. This is, I think, old,
Yes, Your Lordship.
of a public service vehicle.
Except gratuitous passenger of a goods
No,
vehicle, Your
yes. No, no. such.
Mm.
Caused by or arising out of the use of the vehicle
Mm.
this is old one. And then according to him, they are covered by the old one.
Your Lordship, it's clear, Your Lordship. It's written goods
What it says,
vehicle, Your Lordship.
that is new, I think, after amendment.
Yes,
Yes, Your Lordship.
That is after amendment.
Lordship,
That is also.
here,
So
courageous
the
person,
two is for, according to you, two is for,
2 plus 1.
no, 147 B.
Yes.
B
147, little changes in the wordings are there, under the 1988, 1994, prior to 1994 amendment. This is courageous passenger is mentioned. Courageous passenger means in the past, example, in the past, a person may travel without paying fee.
Yes, without
That
paying
is not
any
covered.
amount.
It is
But then here is a case where he paid your
right
fare.
charges.
A good was carried, and for that also he paid.
Your Lordship,
Is there any, has it come in your evidence?
Your Lordship,
Yeah,
it has come, Your Lordship.
Pleading as well as the evidence.
Your Lordship,
It is not even impeached in the cross-examination. The respondent body, none of them has impeached it.
Where do we find that in the evidence?
Yes, can you see? Well, you see the affidavit in evidence in the affidavit of
Have you
PW1.
annexed it?
It is not annexed, it is in the law court reports. You know, it is, no paper box has been prepared. That is the problem.
In the evidence of
Evidence of PW1, but it's the wife of the deceased.
PW1 page in your document page.
It is in paragraph number 5 of the evidence in affidavit. That is the
No,
page 3.
Just
Yeah, that is.
flag it.
That is not the affidavit. No, the evidence should be here. You know, let's see. This form.
Can you find it out? Yeah. No, flag it.
This is the.
Can you read?
I may be allowed to read it from paragraph number 4 of the
This is
evidence in affidavit.
PW1 is a claimant.
Yes, claimant number 1 evidence.
Okay.
So kindly see paragraph number 4, relevant portion,
Paragraph 4.
paragraph 4.
Yes.
I state that as the salary of my deceased husband could not manage to meet the minimum required expenses of the family because of the children's schooling in other places. Since other than a primary school, there is no other school institution in Longchong. Longchong is the place of residence of the deceased family. Therefore, a wayside provision shop and hotel attached to our residential building located on the west side of Mokokchung Mariani Road was maintained by our family. It is correct that we used to procure the commercial goods from the provision for the provision shop as well as for the hotel from Mariani town in Assam, which is much cheaper than the local Mokokchung town. And usually after his government duty is over, during the evening, my late husband used to go to Mariani for bringing commercial goods. And normally, he used to return back during the midnight or early morning hours. Then, paragraph 5. I state that during the evening on 16/2/2014, my late husband went to Marani for bringing some goods for sale in our family wayside provision shop and hotel. As per information from my late husband over mobile phone, the loaded truck bearing registration number so coming from Jorat and heading towards Mokokchung arrived at railway gate area in Marani town about 9 p.m. Therefore, my late husband on payment of freight charges of rupees 2,500 to the driver of the truck loaded some boxes of fruits, some baskets of grain vegetables and several other miscellaneous items in the truck and proceeded the onward journey. It is correct that I had last contacted with my late husband over mobile phone at about 10:30 p.m. on 16/02/2014, which was the time the truck passed through the Assam Rifle check gate at Longtho in Marani Mokokchung Road. I state that goods laden truck normally takes 1 to 2 hours from Longtho to Longchonggo. However, even up to 1 a.m. on 17/02/2014, the truck did not arrive in Longchonggo, nor I could contact my husband over mobile phone despite frantic attempts many times. Then,
there is no cross.
yes, that is the proof. On what capacity the deceased was traveling in the truck. He was traveling along with his goods on payment of freight charges.
Lordship, this issue was reflected in that order, your Lordship. Issue number 1, your Lordship, definitely reflected your Lordship.
Lordship, we kindly see paragraph number 9 of the evidence. Affidavit in evidence, evidence in affidavit. Paragraph number 9 is also relevant.
What it says?
Paragraph number 9.
There is no cross examination.
There was, but limited only. Very limited. So paragraph number 9. I state that despite frequent and repeated attempts over mobile phone to contact my mother, sister, and also my husband, I could not keep contact with any of them nor receive any information about your whereabouts. Thus, when I and our neighbors were all alarmed by the situation, it was at about 10:30 a.m. Some people coming from Changi X Junction informed us that there was a motor vehicle accident below Changi village However, due to bad weather condition and extreme difficulty in accessibility of the area, nothing is known of the casualty, if any, or the type of the vehicle involved in the accident. Thus, serious suspicion arose, apprehending that my deceased husband might have involved in the said accident. I said that immediately after coming to know the information about the accident of the unknown vehicle, I informed over mobile phone to my brother-in-law, Sri Lanowati, the elder brother of the deceased husband, residing at Chungia village. However, till then I did not apprehend anything.
This is regarding accident only?
Yes. So it was at about 12:30 to 1 p.m. on my frequent attempt to contact the mobile phone of my deceased husband. Mobile phone ringing was made available and responded by a female voice from a hospital in Mariani, which claimed to be a nurse attending the injured victim of a motor vehicle accident. On inquiry, it was responded that the victim happened to be the handyman of the truck involved in the accident. However, sustained only minor injuries and undergoing medical treatment in Mariani Hospital. Over the mobile phone, the said handyman also informed me the facts as to how the accident occurred and the involvement of the owner of the mobile phone, who was no other than my deceased husband. It is correct that the mobile phone of my deceased husband was returned to me after about 4 days through a truck driver. That is the case.
Okay, so only the, what we have to examine here in this
Then-
case
then-
is whether the insurance can be made liable.
Lordship.
So, Roshi, may kindly see.
The facts are not disputed.
Facts are not disputed, Your Lordship.
Mm.
And Your
Facts
Lord-
are not disputed.
No, Your Lordship. Your Lordship, and the same issue, Your Lordship, it have been reflected in the issue number 1, Your Lordship, finding and decision to Your Lordship.
Hmm.
Your Lordship, if Your Lordship would come to page 33, Your Lordship, of the appeal,
Just a minute.
it's clearly mentioned, Your Lordship. Page 3, Your Lordship. The relevant portion, Your Lordship.
Yes.
Lordship, the last paragraph, Your Lordship. However, the claimant.
Page 33.
Yes, Your Lordship. The last paragraph, Your Lordship.
Yes.
Lordship, if I may be allowed to read it, Your Lordship.
Hmm.
That the claimant has already clearly mentioned in para 8(2) of the claim petition that the deceased was traveling by the said truck heading for its destination, Longchongkong, accommodating the goods after paying 2,500 as freight charges, Your Lordship. Thus, as per the facts and circumstances of the case, so and so, Your Lordship, the deceased was traveling in the truck as a gratuitous passenger, Your Lordship. Your Lordship, here the freight charges, Your
We
Lordship.
have read it already earlier.
Yes, Your
We
Lordship.
have
Your
read
Lordship,
it.
the freight charges.
So
Your Lordship.
according to you, the claimant was only a gratuitous
Yes, Your Lordship.
traveler.
Your Lordship, and their.
And therefore not entitled.
Yes, Your
And
Lordship.
the insurance also, policy also cover only
Yes, Your Lordship.
one plus one, 2.
Yes, Your Lordship. And
Not the
gratuitous passenger, Your Lordship.
passenger.
And Your Lordship, if you appreciate the fact that freight charges are amount paid to the carrier company for the transport, Your Lordship, not the driver, Your Lordship. Freight charges, Your Lordship. The fare, the amount which the deceased have given, Your Lordship, are to be paid to the company of the transport, Your Lordship, not the driver, Your Lordship.
Paid to the
Company, Your Lordship. Company and the owner of the truck owner, Your Lordship.
company.
Yes, Your Lordship. And the freight charges are not to be paid to the truck driver or the handyman, Your Lordship.
No, no.
The vehicle is owned by a
where
private
have
individual.
where have you said in your evidence? Just a minute. In your evidence that the husband of the claimant has paid a freight charges. Have you stated in the evidence?
To the driver of the vehicle. it is-
Where have you stated? In the evidence?
Yes, it's stated in the evidence.
Evidence of PW1.
Yes, PWI.
Which para?
Paragraph number 5. Paragraph number 5. I state that during the evening on 16/02/2014, my late husband went to Marani for bringing some goods for sale in our family wayside provision shop and hotel. As for information from my late husband of mobile phone, the loaded truck bearing registration number so coming from Chorak and heading towards Mokokchong arrived at railway gate area in Marani town. Because railway gate is in the midst of the town, small town.
No, where it is payment is stated?
It is at paragraph number 5 of the evidence in affidavit, paragraph number 5. Can you see?
No, where it is said that it is he had paid
Yes, let me be allowed
on
to.
payment of right,
Yeah. Ask for information from my late husband.
2,500.
Yes, 2000 to the driver of the truck. It was paid to the driver of the truck. It is a commercial truck. It is open to the public, not actually the owner of the vehicle. Owner of the vehicle may be somewhere else. The commercial truck is elsewhere all over India. Driver has to engage the courts. That is the practice.
But then he had boarded on the way, so that is why he had to pay to the driver. And driver
Yes.
had a capacity to carry.
Courts can be loaded here and there,
Yes.
not necessarily in a particular place alone.
Lordship, as per the reflection by the tribunal, Your Lordship, it is clear that the driver and the handyman was the only licensed passenger, Your Lordship. Your Lordship, it is clear from that, Your Lordship.
Where it says?
Lordship, the order, Your Lordship, page 39, Your Lordship. The order which I've earlier read, Your Lordship, page 39, Your Lordship, the authority portion. From the truck, Your Lordship, the truck, Your Lordship. If I may be allowed to repeat, Your Lordship.
From the truck.
The truck bearing number so and so.
Okay, the vehicle truck.
Yes, Your Lordship.
Okay.
Which was involved in the accident was undoubtedly a good carriage vehicle, and the insurance company covers the vehicle as per the terms and conditions of the policy laid down, Your Lordship. The terms and conditions of the insurance company are very clear and categorically, and it creates a specific power on carrying passenger, except employees, except not exceeding the permitted in the registration document, coming under the purview of the Compensation Act 1923. According to the registration, the number of employee passengers permitted is 1, excluding driver, Your Lordship. That's clear, Your Lordship. In Your Lordship, there are several rulings, Your Lordship, by the Supreme Court as well as the Gauhati High Court, Your Lordship, stating a gratuitous passenger, Your Lordship, is not covered under the policy of the insured company, Your Lordship. Your Lordship. Lordship, if I may be allowed to place some rulings, Your Lordship.
Yes.
Rulings, Your Lordship.
Ruling.
Lordship.
So what we can do, we can continue at 2.
Yes.
Lordship.
Okay.
Yes, all right.
How much more time you will take? Counsel for the petition, appellant? No, 4. You?
No, it depends upon the issue that will be raised
Okay.
by your lordship to be clarified.
You also, I think.
Yes, Your
Few
Lordship.
more
Much time,
minutes?
Your Lordship.
Okay.
It didn't
Then
take
we'll
much time.
resume at 2.
Lordship.
Yes, lordship.
Yes, time. You have remind. Good. Remain on time.
Thank you, Lord. Make it a beginning.
Club together. And then along with the visa, no?
says let the matter be taken along with so and so and so.
7대 possibility na. Oh, 8대
Oh,
고.
8대 나?
너네도 7대 7대도 로시도 나. 8대도 빨리 떼고 이기에서 analyze.
생동은 어떻게?
Oh, kare.
Huh?
Yes.
18 or possible to take it along with. Enough, right?
Take it along together.
야, Mumbai. 제 적죠, 저거, 저거랑 뭐한 거 보고. 미자, 안에 이사 local system 지금 알아, 고시면 나오는데. 수능 걸 짜시면 나올 것 같아, 말레이시아요. 이사가 비를 잘 오래, 아와 이거 오늘 와봐야 근데 수능 걸 뒤지니까 그래서 어제 얘기를 해요. Joint and several level it was a single out child with a question. Lila Honda. It's all not just me, yes, I shared. Yeah.
which kaya in he? So do Kylie Shola, totally. Get anything?
What?
Chapel Shola.
Hey, she do. Hey, Chabi, I wouldn't know you.
Third. Number code number one to be like number one. Tahi sis ko. Oh, so by the
Nah, 1988 ini itu purana kita jadi mana sih orang ini itu 1999 anu masih ada itu tuh 1999 anu masih nah itu 1994 iki sudah tuh itu dia anu itu kuat 2019 anu naga asal latest lagi itu orang lagi itu ada eksin ini
Nah, ini kalau mikir kalau punya nak kami ada bikin itu ada insentif itu dan lain.
Itu udah oleh. Point. Proses itu. Ini dulu, mulai mana lagi?
Itu biasa ini salah. Terus nak dulu. Weh, langsung jahat tu ni. Kalau kita jalan dengan jalan bersih, tu pun biar mana lah. Biar lah. Lak tu ni. Yaudah. Dah ya. Langsung kayak dulu. Ini berjalan langsung dulu. Kita cuba dulu. Tidurnya. Ini itu saya. No, port trigger, it was heater line to be on. Port three.
Không hợp thế mà.
Oh, render cái này just machine double.
Right is Honeymoon 22, sitting one. One. Lordship,
Yes.
the grounds on which the tribunal exonerated the insurance company from the liability is reflected here in the Byung judgment. Kindly see page 33. Internal page 33, the Byung judgment. Page 33.
Yes.
Byung
What is
judgment.
reflected? You said
The relevant findings.
findings.
Why the learned member of the tribunal was placed to exonerate the insurance company? The reason starts from here. So, kindly see paragraph number 17.
Yes.
Paragraph number 17 is finding and decision. Issue number 1. Under what facts and circumstances the deceased persons were involved in the accident? So now the learned member of the tribunal examined the measures. Kindly see the last paragraph here. At this page, kindly see the last paragraph. The claimant had also clearly mentioned in paragraph number 8, subparagraph 2 of the claim petition that the deceased also traveled by the said truck heading for its destination Longchongkong, accompanying the loaded goods after paying rupees 2,500 as freight charges. Thus, as per the, kindly turn to the next page. Thus, as per the facts and circumstances of the case, late Cindy Limbaugh was traveling in the truck as a courteous passenger. This is the folly. This is totally a folly of the judgment. Not only erroneous, but this is the fallacy. Clearly, the learned member of the tribunal has stated.
Let us see your ground for affid.
Yes.
Ground taken.
The grounds of challenge, that is started from page number 11 of the memo of appeal.
Yes. Main ground.
Ground 2, ground remodel 2. For that, the evidence is recorded by the tribunal during the trial and evidence were not at all perused and discussed by the learned member of the tribunal, learned member of the MSCT, in passing the Byung judgment and award, thus leading to erroneous and arbitrary finding, making an impasse in the very text of the Byung judgment and award, holding that it is crystal clear that the deceased was a courteous passenger in the truck involved in the accident. Hence, the learned member of the MSCT palatally erred for not at all discussing the legal liability of the insurer under section 147 subsection 1 and section 149(1) of the MA 1988.
So this is with reference to the para 17.
Yes, yes.
Especially. Okay.
Yes.
Okay, then next.
Yes.
Next
This-
important.
Then next ground.
Ground.
For that, the unreported pleadings in paragraph number 8 and 2 of the claim application and the unimpeached evidence of PW1 in paragraph number 5 of the evidence in affidavit that the deceased was traveling in the truck accompanying his goods carried in the truck on payment of freight charges of rupees 2,500 were not at all examined by the learned member of the MSC.
It has not been reflected in the judgment.
The judgment is
Payment of the
reflected,
freight
but
charge
it's
of
not
2,500.
Yes, Lordship, it is,
Nowhere reflected is.
it is reflected in the judgment.
It's reflected, Your Lordship.
Reflected.
It's reflected.
Okay. Okay, then next.
It is reflected, but it was not wheat in the balance under the law. It should be wheat.
Reflected but not appreciated.
Yeah.
Okay.
There was a very serious error for not appreciating the unimpeached evidence. And paragraph number 4.
Four
Roman
is
numeral paragraph
also
4.
relevant.
Yeah, all of this are relevant.
Okay.
For that, why paragraph number 17, subparagraph 3 of the Young Judgment and Award, the learned member of the MACD rightly referred to the undenied and unreported pleadings of the appellant in paragraph number 8, subparagraph 2 of the claim application that the deceased traveled by the street truck heading for its destination Long Chong Kong, accompanying.
This is, I think, more or less repetition.
Yes, a repetition, but little bit more points are there. So that is the case. So kindly see the Young Judgment.
Yes, para 17 we have read. Para especially 3, subpara 3.
Para 17 of the Young Judgment.
Yes, we have read.
Yes, we have once read already. In para 17, it is all as I read right now. That the claimant had also clearly mentioned in paragraph number. Yes, already read. And then coming to another wrong finding.
Then
another wrong finding is at paragraph, no paragraph. It is mentioned in page number 39. Kindly see page 39.
Page 39.
Page 39. From second paragraph.
Yes.
That the vehicle, truck, carrying registration number so, which was involved in the accident was undoubtedly a coach carriage vehicle, and the insurance policy covers use of the vehicle as per the terms and conditions laid down by its policy. In the policy, it is very clear. Chapter 9 and chapter 10 and 11 clearly covered. The terms and conditions of the insurance policy are very clear and categorically, and it creates a specific part on carrying any passenger except employees not exceeding the number permitted in the registration document and coming under the purview of the Workmen's Compensation Act. According to the registration certificate, Exhibit P6, the number of employees passengers permitted 1, excluding driver. That is lit Sentinel number 15 of 2015 was therefore traveling in the offending truck as a courteous passenger, as there was a handyman with the driver, and as such, there is a clear violation of the policy. This is the cryptic finding. Totally it is cryptic. The learned member of the tribunal categorically held that the deceased was traveling along with his coats, carried in the truck on payment of freight charges.
Do you have any power? Oh, sorry. The ruling on this, that a person traveling along with the goods.
Oh, definitely, so many good decisions.
Okay, you also won.
Yes. The learned member of the tribunal relied on five numbers of decided cases of the Honorable Supreme Court, which were sought to be relied, but all are in my favor.
All are in your favor.
Yeah. In one way or the other, all are in my favor. 2000. Finally, see 2004 ECC. Sorry. Two 2005 12 ECC. Ada pandal. Pandal is this is No, no, it is not here. The bundle is there. Okay. No, no, that is ECG or ECC, another different bundle. It was here. Sorry. So, Lordship, the learned member of the tribunal sought to rely on a case decided by the Honorable Supreme Court, reported in 2013 11 SCC 554. Two thousand 11 SCC 554. This is the case of United India, United National Insurance
The
Company.
copy may be furnished. Copy may be furnished, huh?
Yes.
Printed copy. 2000?
2013 11 SCC 554.
Para?
Para 8 and 10, kindly. Para 8 and 10 are relevant. This was a marriage party case.
What case?
Marriage party. A marriage party was traveling in a truck. This is called Bharat. In the judgment, it is mentioned Bharat.
Bharat.
In English, it is called marriage party. Marriage party.
Okay.
The marriage party was traveling in a truck. The truck met with an accident. And giving rise to the matter coming up to the Supreme Court. So the Supreme Court held that marriage party definitely they are creditors passengers. Because they are not the owner of goods carried in the truck. Because marriage party, these parties are not.
The truck is not meant for passengers.
Yeah, definitely. That is the finding. So,
but here in this case provided.
Yes. But
read the relevant portion.
Relevant portion is, can you see it, paragraph number 8?
8.
Yes, para 8.
Yes.
After having gone through the hours of the claims tribunal and the judgment and order passed by the learned single judge of the Honorable High Court, we are not able to understand.
No, where are you reading? Para 8, page 562.
Yeah, but 557. Page 557.
No, it's not same. Okay, but para 8.
Yes, paragraph 8.
It start with?
After having gone through the hours.
No. I think this is SCC. And yours is?
This is SCC 2013 11 SCC 554.
Printed from? I think the para 8 is reference may also be made. It start with.
This is the case of National Insurance Company Limited versus Savitri TV, like that.
No, CP Subhas. This is different. Let's see. Compare it.
In the Enthong judgment, it is given 2013 11 ECC. This is the judgment.
Is this is
Para 8.
8. Kindly read.
After having gone through the awards of the claims tribunal and the judgment and order passed by the learned single judge of the High Court, we are not able to understand as to how.
Is it same?
Yes, this is the same.
Okay.
Same reporting.
Yes. Paragraph. Para 8?
Paragraph 8 and 10.
Okay.
Paragraph 8.
Just a minute. National insurance. Okay, that was.
This judgment was relied by the learned member of the tribunal. It is
Yes.
After having gone through the award of the claims tribunal and the judgment and order passed by the learned single judge of the High Court, we are not able to understand as to how it has been found that the ambulance insurance company can still be held liable to pay the amount of compensation as there has been a categorical finding by both the courts below that the vehicle in question was insured only as a course carrying vehicle.
Yeah, just a minute.
The
Categorical finding by both the courts recording that the vehicle in question was insured only as
goods carrying vehicle.
goods carrying vehicle. Okay.
The custom of carrying parat. There was a practice, custom to carry marriage party. The custom of carrying parat in the village on the said truck will not be sufficient to hold the ambulance insurance company liable to pay the amount of compensation. Immediately, the ambulance insurance company would not know unless the accident takes place so far as what purpose the vehicle in question was being used. The terms and conditions of the insurance policy are very clear and categorical, and it creates a specific part on carrying out any passenger except employees other than driver, not exceeding 6 in number, who should have come under the purview of the Workmen's Compensation Act. Then kindly come to paragraph 10.
Yes.
Dealing with the similar circumstances, this court in the case of National Insurance Company Limited versus Bumiti Subamaya, as under it is reported in ACC page 246, paragraph 10 and 11. Then quote 9 to 20, it is therefore manifest that in spite of the amendment of 1994, the ethical provisions contained in section 147 with respect to person other than the owner of goods or is authorized representative remains the same. Although the owner of goods or is authorized representative would now be covered by the policy of insurance in respect of the goods vehicle, it was not the intention of the legislature to provide for the liability of the insurer with respect to passengers, especially courageous passengers, who were neither contemplated at the time the contract of insurance was entered, nor was any premium paid to the extent of the benefit of insurance to such category of people. So, very clear.
Is this case in your favor?
Yes, because here, other than owner of goods or is authorized representative. Kindly see, section 147. It is therefore manifest that in spite of the amendment of 1994, since 1994 Amendment Act of section 147, owner of goods who is authorized representative was aided, covered by the Act policy. So this is reflected here. The ethic of the provisions contained in section 147 with respect to persons other than the owner of goods or is authorized representative remains the same. For others, it remains the same. But other than the owner of goods who is authorized representative, owner of goods and or his authorized representatives are accepted. They are covered.
The provision continues with respect to the person, the order of the goods.
So this decision comes in my favor. Because I was traveling, the disease was traveling as the owner of goods, not as a courageous passenger.
No, para 8 is against you only.
Because I was not a courageous passenger, so it cannot be against me. For courageous passenger, definitely it shall not be covered. But the disease was not a courageous passenger. Nobody says that the disease was a courageous passenger. There is no pleading, no evidence. Neither pleading, no evidence that the disease was a courageous passenger. Even the defendant did not refute it.
Person other than the owner of the good or this.
Now coming to the other desired cases relied upon.
No, how this is in your favor?
Other than is in my favor. Other than the owner of courts or is authorized representative. I am the deceased was the owner of the courts. Whereas in this reported case, the passengers were carrying in a truck marriage party. A Bharat party was carried in the truck, not courts. Instead of carrying
They are not
courts,
entitled. They are entitled or not? The passenger of marriage party, they are entitled? Are
no.
they entitled?
Supreme Court has ruled. Supreme Court has overturned the finding of the lower court as well as MSCG as well as the High Court. High Court single judge relying on Satpal Singh case held that they are covered by the policy. Third party means other than the owner and insurer. But Satpal Singh case has been overruled by Ashar Energy case. That is why the Supreme Court relied on it. The Supreme Court set aside the young.
So this is otherwise not in favor, except for other than the owner.
Yes, yes, that is the principle of law.
Other than the owner of the goods.
Yes. That exception covers my case.
So since you are the owner of the goods,
yes,
you are entitled.
Yes, I am covered. The liability is present, liability is covered. And Lordship may kindly go through the other decided cases. It will be read with other decided cases.
So this is in which case National Insurance Company Limited versus Gauhati.
Savitri TV and others.
Hmm?
National Insurance Company versus Savitri TV and others.
No, where? Which one?
The one which we are talking now.
Wait, another one?
No. Second one is different.
Second one?
Second one yet to be referred.
Okay. Yes.
The learned
This
member
is-
of the tribunal, Lordship,
Yes,
the learned member of the tribunal.
Just a minute. So it's not exceeding the permitted number.
There was a fallacious appreciation of the evidence, following which irrelevant judgments were relied. That is the case. The deceased was held to be courteous, not owner of courts. That is why irrelevant judgment has been relied.
Yes. What is the another one?
The second judgment relied by the learned member of the tribunal, it is reflected in page number 38.
So this printed copy would be requiring this one.
2005, 5 243.
This printed copy would require. This is 2005.
2005, 5 ACC 243.
242. 24?
243. The relevant portions are para 2 and para 9. Para 2 and para 9. In this judgment, the learned member of the tribunal relied However, this was a misplaced reliance. Paragraph 2 is the facts of the case. Paragraph 2. The facts, shall I read, Lordship?
Yes.
The fact of the matter is in a narrow compass. One Sri Pumiti Kundala Rao, since deceased was traveling in a lorry bearing registration number so on 5/11/1995. The said lorry met with an accident resulting in the death of the said Sri so. On a claim application filed by heirs of the said deceased, the fourth edition of district judge is Godavari district awarded compensation for the death of the said deceased so for a sum of rupees 1,30,000 with interest at a rate of 12% per annum. The motor accident claims tribunal, however, was of the opinion that the appellate hearing was not able to pay the said amount of compensation as the deceased was traveling in a lorry as a courteous passenger. The said award passed by the Motor Vehicle Accident Claims Tribunal came to the question before the High Court, which was noticed here and above, was reversed by the High Court, relying on or on the basis of the decision of this court in New India Assurance Company versus Satpal Singh. This is just a reverse Satpal Singh case. Then, coming to paragraph number 9. The question again come up for consideration before a three-judge bench of this court, of which we are members. National Insurance Company Limited versus Baljeet Kaur, wherein, upon considering the effects of the amendment carried out in Section 147 of the Motor Vehicles Act 1988 by the Motor Vehicles Amendment Act 1994, it was opined then, quote, Para 17, by reason of the 1994 amendment, what was added was including owner of goods or his authorized representative carried in the vehicle. The liability of the owner of the vehicle to insure it compulsorily, thus by reason of the aforementioned amendment included only the owner of goods or his authorized representative carried in the vehicle besides third parties. The intention of the parliament, therefore, could not have been that the words any person occurring in Section 147 would cover all persons who were traveling in a coach carriage in any capacity whatsoever. If such was the intention, there was no necessity of Parliament to carry out the amendment, inasmuch as the expression any person contained in such clause 1 of clause B of subsection 1 of Section 147 would have included the owner of goods or his authorized representative besides the passengers who are courageous passengers or otherwise. Here, in this reported case, the deceased was traveling in a goods-carrying truck as a courageous passenger, not carrying any goods. He was not carrying any goods. He was a courageous passenger. However, the learned single judge of the Honorable High Court, relying on the decision rendered in Satpal Singh case, held that third party includes any passenger. Third party means it includes any passenger, whether it is public service vehicle or goods carrying vehicle. Any passenger is a third person as seeking insurance and owner of goods. That was the decision. However, the Honorable Supreme Court in this reported case, it was categorically held that except owner of goods or his authorized representative, which were impressed under the 1994 Amendment Act, the risks are not covered. So the Honorable Supreme High Court judgment was set aside. That is the case. That deceased was traveling in the goods vehicle, not as an owner of goods, but as a courageous passenger. That is the case. So here also it clearly says that by the amendment of 1994, Section 147 amendment, amended by 1994, owner of goods or its authorized representatives are included under the compulsory insurance in terms of Section 147 of the in the Act 1988. That is the case, very clear. All courts and authorized beneficiaries are covered under the policy. Then coming to another decision relied by the learned single judge, learned member of the tribunal. Two 2004, it is ECC 517. That is Brahmo. 2004, it is ECC 517. Here, auto rickshaw was plying without permit, route permit. In this rewarded case. Kindly see
Relevant para.
paragraph number 13, 312 and 13. 312 and 13. Paragraph number 3 is the background of the case.
Yes.
Three persons were traveling in an auto rickshaw which met with an accident on 9/5/1992. Two persons lost their lives while one was seriously injured. Claim petitions were filed by the legal representatives of the two deceased persons, while the injured filed a separate petition claiming compensation in terms of Section 166 of the Motor Vehicles Act 1988. Herein, the short the act. The auto rickshaw in question belonged to Jila Atiya, here referred to as the insured. The insured resisted his claim on the ground that insured had not obtained permit to ply the vehicle, and therefore, in terms of the policy of the insurance, the insured had no liability. The motor vehicles accident claims tribunal, Krishna at Vijayawada, accepted the plea. It, however, held that the insured was liable to pay compensation, which was fixed at rupees so in case of death, while in the case of injured, the claim sum was rupees so, which was directed to be paid. The judgment was challenged in appeal before the division bench of the High Court of Andhra Pradesh at Hyderabad, questioning the correctness of the view regarding non-liability of the insured. The High Court, by impugned judgment, held that the insured was liable to indemnify the award. Then, kindly come to para 12. Kindly come to para 12.
Yes.
The High Court was of the view that since there was no permit, the question of violation of any condition thereof does not arise. That is
Since there was no
judicial
permit. The question of violation of this condition.
There was no permit. Question of violation of the permit, conditions of the terms and conditions of the insurance does not arise. The view is clearly fallacious. A person without permit to ply a vehicle cannot be placed on a pedestal vis-a-vis one who has a permit, but has violated any condition thereof. Flying of a vehicle without a permit is an infraction. Therefore, in terms of Section 149, subsection 2, defense is available to the insured on that aspect. The acceptability of the stand is a matter of adjudication. The question of policy being operative and no relevance for the issue regarding liability of the insured. The High Court was therefore not justified in holding the insured liable. Then, kindly come to paragraph 13. The residual question is what would be the appropriate direction considering the beneficial object of the Act. it would be proper for the insured to satisfy the award, though in law it is no liability. In some cases, the insured has been given the option and liberty to recover the amount from the insured for the purpose of recovering the amount paid by the owner. Insured shall be required to file a suit. It may initiate, shall not be required to file a suit. It may initiate the proceeding before the executing court concerned, as if the dispute between the insurer and the owner was the subject matter of the initiation before the tribunal, and the issue is decided against the owner and in favor of the insured. So here, the auto rickshaw was plying without road permit, without permit at all. The deceased persons were traveling in this auto rickshaw, which does not have road permit to ply. So definitely the insurance company was exonerated. However, the learned Honorable Supreme Court held that in this kind of situation, the insurance company should pay the liability and recover the amount from the owner of the vehicle. That is the direction given in paragraph 13. But here in my case, absolutely the insurance company was absolved. Even when there is a clear violation of the law, even then, the claimants were given the right to recover the amount from the insurance company, and the insurance company shall recover the amount from the insured vehicle owner. That is the case. But all these matters were overlooked by the learned member of the tribunal here in my case. And now coming to another decision. 2004 ECC 667. 2004 ECC 667.
The same.
No, in the same volume, but different cases. In the same volume. 2004 ECC, page number 667.
Yes.
Here,
Yeah.
para number 7, 10, 12. Here in this case, a truck laden with scent was carrying numbers of passengers. Paragraph number 7 onwards.
Yes.
The tribunal found that the accident took place when it was coming from Haridwar laden with scent. 30 to 40 persons were sitting on the scent and at a place called Chandikat. The said persons claimed on the truck and it overturned, resulting in the accident. So definitely it cannot be this judgment cannot be compared with my case. The 3 persons died, including the deceased, and several others were injured. According to the witnesses examined, none of them claimed on the truck forcibly. On the other hand, he had paid fare for traveling in the truck. He stated that Rs 25 per passenger as fare was taken. The driver was examined as TW1. According to him, a number of persons forcibly claimed on the truck, and as a result, the truck met with an accident. He admitted that there was a conductor in the vehicle who ran away from the place of accident. He also admitted in his written statement that persons forcibly claimed on the truck and 30 to 40 persons were in the truck. Analyzing the evidence, the tribunal came to hold that the conductor of the truck had collected fare and the person had not claimed forcibly. In these circumstances, taking into account the age of the deceased and his estimated income, it was held that the claimants were entitled to Rs so and so as compensation. It was further held that the vehicle was the court's vehicle and the owner had not insured the vehicle for carrying passengers in the court's vehicle. Only the driver, conductor, and certain numbers of labor would be carried, but there was no scope for carrying any passenger. Taking note of the terms and conditions of the policy, note it was held that insurer was not able to make the payment of the compensation, and it was the owner who has to make the payment of the awarded amount with interest at the rate of so-and-so per annum from the date of presentation of the claim petition. As noted above, the appeal filed by the owner from driver before the High Court did not bring any relief to them. Now, coming to paragraph number 10. It is to be noted that in Ramesh Kumar versus National Insurance Company Limited, it was held that though the vehicle concerned was the court's vehicle, yet the liability of the insurance company was not wiped out. The decision was subsequently reversed by a three-judge bench of this court in New India Insurance Company versus Asarani, which was followed by Oriental Insurance Company Limited versus DVD conduct regime. Recently, in National Insurance Company Limited versus Baltic, the Africa 1994 amendment, vis-a-vis section 147 of the Act was considered. It was observed as follows. Page so. Within inverted comma, quote, paragraph 17. By reason of 1994 amendment, what was included, what was added is the including owner of post or his authorized representative carried in the vehicle. The liability of the owner of the vehicle to insure it compulsorily, thus, by reasons of the aforesaid amendment, included only the owner of post or his authorized representatives in the vehicle, besides third parties. The intention of the parliament, therefore, would not have been that the words any person, including any person occurring in section 147 would not have been brought, section 147 could cover all persons who are traveling in a court's vehicle in any capacity whatsoever. If such was the intention, there was no necessity of parliament to carry out the amendment, inasmuch as the expression any person contained in subclause 1 of clause B of subsection 1 of section 147 would have included the owner of courts who is authorized representative, besides the passenger who are courteous or otherwise. Then para 19, in Asharani, it has been noticed that subclause 1 of clause B of subsection 1 of section 147 of the Motor Vehicle Act 1988 speaks of liability, which may be incurred by the owner of the vehicle in respect of to bodily injury to any person, damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. Furthermore, an owner of a passenger carrying vehicle must be premium for covering the risks of the passenger traveling in the vehicle. The premium in view of 1994 Amendment Act would only cover a third party as also the owner of courts or its authorized representative, and not any passenger carried in the court's vehicle, whether for hire or reward or otherwise. Very clear decision of the Honorable Supreme Court. But this decision was overlooked by the little member of the tribunal. The little member of the tribunal in the new judgment, this decision is written, but relevant parts have been not digested. Critically and tactfully, this relevant portion was not digested. That is the case. On the contrary, the little member of the tribunal held that the deceased was a courteous passenger, not the goods owner carried in the vehicle. Then another decision relied upon by the lower learned court, lower learned tribunal. 2004, it is received. 2004, it is page 667.
667 we have just read. This is 697.
This is a different thing. This is a different case. This is owner of goods in a tractor. A tractor trailer was carrying goods.
2004 8 SEC 697 it must be.
697.
Yes.
2004, it is 694. 697, I mean. 697. Sorry. Paragraph
Relevant.
13, 14, and 16. 13, 14, and 16. This is a
Yes.
This reported case is the one where a tractor trailer was carrying goods belonging to the deceased. The deceased was traveling by the tractor trailer, which was carrying his goods. But the court held that a tractor trailer has been insured for agricultural purpose, not for carrying goods. A tractor is an agricultural implement, mechanical implement, not to carry goods in the highway. That is the case. So kindly see paragraph 13. The effect of 1994 amendment came for consideration before three-judge bench of this court in National Insurance Company versus Baltic Car. Just recently digested.
So the same, I think.
Yes, same. But the learned member of the tribunal relied upon this. Leaving aside the omitting to digest the relevant paragraph. Here, owner of goods is covered. You clearly see it.
Para 13.
Yes, paragraph 13, 14. Kindly see paragraph 13, 14, and 16. Let me read. Shall I be?
Yes.
Read out?
Yes, please.
13. And now from the second paragraph, paragraph 13, subpara is within code 19. In Asharani, it has been noticed that clause 1 of clause B of subsection 1 of section 147 of the MA Act of the 1988 Act specs of liability, which will be incurred by the owner of a vehicle in respect of deed of or particularly injury to any person or damage to any property of a third party caused by or arising out of the use of the vehicle in the public place. Furthermore, an owner of the passenger carrying vehicle must be premium for covering the risks of passengers traveling in the vehicle. The premium in view of the 1994 amendment would only cover a third party as also the owner of goods or its authorized representative and not any passenger carried in the goods vehicle, whether for hire or reward or otherwise. So my case is absolutely covered. Now coming to paragraph 14. An insurance for an owner of goods or its authorized representative traveling in a vehicle become compulsory only with effect from 14/11/1994 from the date of coming into force of the Amendment Act 54 of 1994. So, Lordship, my case is covered by this because the accident occurred in 2014. Accident occurred on 17 February 2014. So 1994 Amendment Act has covered my case.
Accident occurred on?
It occurred on 17 February 17 to 1914. 2014, I mean. 2014.
Yes.
Kindly come to para 16 also. Para 16 also speaks of what? importance is here. Relevancy. Paragraph 16. A tractor fitted with a trailer may or may not answer the definition of goods carriage contained in section 2, clause 14 of the Motor Vehicles Act. The tractor was meant to be used for agricultural purposes. The trailer attached to the tractor thus necessarily is required to be used for agricultural purposes unless registered otherwise. So the vehicle involved in this case where the disease was traveling was a tractor trailer which was registered for agricultural purposes and for not carriage of goods. So coming to paragraph 17, for the reason aforesaid, the enjoined judgment cannot be sustained, which are set aside. Accordingly, the appeal is allowed in the facts and circumstances of the case. These are the no orders first. So the learned member of the tribunal relied upon this judgment, which is highly irrelevant to my case. Rather, the reference made in this judgment is favorable to me, favorable to my case. Then here, the learned member of the tribunal has referred to a case. No citation, no reporting has been mentioned here. But this case appears in 2008 5 ACC, 2008 5 ACC, 403 page.
I think it's all the same.
Yes,
Necessary?
yes, owner of courts and authorized representatives are covered by all these decisions, which were digested by the learned member of the tribunal.
Your para?
So almost here the case is covered in para 3. Paragraph 3. The background facts in the nutshell as follows. The accident in the instant case took place on 1/6/1996. The claimant was traveling in a coach carriage as a courteous passenger. Undisputedly, she was not traveling in the coach carriage in the capacity as owner of coach or representative of owner of coach being transported in the coach carriage. This aspect was also accepted by the claimant in the claim petition. It is an admitted case of a courteous passenger in a coach carrying vehicle, not like the present case. Present case is the owner of coach.
Okay. Anything else?
Coverage.
I think the citation is enough.
Number of decisions has been digested in the
almost
no
same.
order, and I want to rely upon 3 judgment decision of the Honorable Supreme Court. It is reported.
Is it different from the? Is it different from the other which we have seen already?
No, it is different. 2004 ECQ. Yes.
Earlier you shown us this code, the 2004 ACJ 881.
Yes. 2004 SAQ 428. You see, paragraph
428 para.
Paragraph number 3, 10, 17, 19, 20, and 21.
What is the difference here? Hmm? You're relying on the monopatra. Monopatra. Okay. They're the same.
Yes, Lordship, the relevant paragraphs are 3, 10, 17, 19, 20, and 21.
Yes. Here also. This is
Well,
National Wisconsin.
I will be allowed to read it. Paragraph number 3. Yes. Respondent number 1.
Yes.
Respondent number 1 hearing preferred a claim
So why
petition.
this has been given? Why this? Hmm? Oh, no, the present one and this one, I think. Yes.
Our libraries do not subscribe ACJ. It should be subscribed.
Okay.
This is one of the most important decisions, not only India, it covers even some of the European countries, including United Kingdom. Respondent number 1, para 3. Respondent number 1, herein preferred a claim petition for compensation before the Motor Accident Claims Tribunal, the TNR, hereinafter referred to as the Claims Tribunal, in view of the death of her 16-year-old son, Sukhinder Singh, due to the allegedly reckless driving by respondent number 2 and the driver of the goods vehicle bearing registration number so. It was found by the claims tribunal that the victim, who was returning in the truck from a marriage ceremony, this is highly irrelevant to my case, died as a result of the rash and negligent driving by the driver of the goods vehicle, respondent number 3, herein. It was admitted fact that the said vehicle was insured with the appellant insurance company. Then kindly come to paragraph number 10. Paragraph number 10. The material proposition of the provisions contained in section 147 of the Motor Vehicles Act 1988 as amended by the Motor Vehicles Amendment Act 1994 reads as follows. Quote, para 147, section 147, requirements of policy and limits of liability. Subsection 1, in order to comply with the requirements of this chapter, a policy of insurance must be a policy which then irrelevant. Then comes to subpara P. Subpara P ensures the presence or classes of persons is specified in the policy to the extent is specified in subsection 2. Then bracket I, against any liability which may be incurred by him in respect of the death or bodily injury to any person, including owner of goods or his authorized representative carried in the vehicle, or damage to any property of a third party caused by or arising out of the use of the vehicle in a public place. So it is very clear, owner of goods and authorized representatives are covered by the insurance policy, which are compulsory in terms of section 147, section 146, read with section 147 of the Motor Vehicles Act. Then coming to paragraph number 17. Paragraph number 17.
Yes.
By reason of the 1994 amendment, what was added is including owner of goods or his authorized representatives carried in the vehicle. The liability of the owner of the vehicle to insure it compulsorily thus by reasons of the aforementioned amendment included only the owner of goods or his authorized representatives carried in the vehicle besides third parties. So this is very clear. Now coming to paragraph number 19. paragraph number 19, in Asharani T 2003 EC1 EC, it has been noticed that sub clause 1 of clause B of subsection 1 of section 147 of the 1988 Act specs of liability which may be incurred by the owner of the vehicle in respect of deed or particular injury to any person or damage to any property of a third party caused by or arising out of the use of the vehicle in the public place. Furthermore, an owner of a passenger carrying vehicle must pay the premium for covering the risks of the passenger traveling in the coach vehicle. The premium in view of the 1994 amendment would only cover a third party as also the owner of coach who is authorized representative and not any passenger carried in a coach vehicle, whether for hire, reward, or otherwise.
This is against the owner of the vehicle.
Yes. Owner of the vehicle is to insure. He is insured. He is insured in terms of section 147. So section 147 includes owner of coach who is authorized representative traveling in the vehicle, which was carrying the coach. 1994 amendment has brought the compulsory liability as against the owner of coach who is authorized representative and also the third party risks. That is the provision. Then coming to paragraph 20.
I think it's all the same.
Yes.
You have already read.
The decision
I've already seen.
continues.
It's all the same.
Section 147 continues
Yes.
unamended till now. But there was a fallacious finding basing on which the learned member of the tribunal passed the review order. That is the case. So kindly turn to
It's fine only. It's all. If it is all the same, it's fine only. That much is enough. It's all the same. All cannot be quoted. There will be numerous.
but here, owner of courts means owners of courts. That is the decision in respect of section 13 of the General Clauses Act. I want to refer to that.
Section?
Section 13 of the General Clauses Act. 1897. General Clauses Act.
Section
Section 13.
of the general clauses.
Section 13 of the General Clauses Act.
What it says?
Subsection 2. Section 13, subsection 2. Words in the singular shall include the plural and vice versa. So owner of courts means owners of courts. Here, subsection 1 says, masculine shall also include feminine. Females also. Similarly, singular shall always include plural. So under the Motor Vehicles Act 1940, section 147, owner of courts is mentioned. But it has to be construed as owners of courts, wherever appropriate.
How it is relevant for this case, in our case?
In our case, the vehicle was half loaded. There were some other owners of course also who were not traveling.
But they
in
were
the
not
truck.
traveling.
So I cannot be treated as a courteous passenger because I am the owner of course. A division bench of the Honorable Allahabad High Court has passed a judgment in this regard. This is reported in 2005
If it
ACK.
is all the same, not required, what I'm saying.
Yes,
It's all
this
the
is,
same. I think this is also regarding 147 or what?
yeah, this is owner of goods means owners of goods.
Yes.
That is what I would like to enlighten before your lord.
Okay.
Yes,
But
the
here that
is,
owner or the owners, singular or plural, is not a question here.
yes, that is not a question, of course.
Hmm.
But the insurance company says that it was loaded in Jorat. Goods belonging to someone else. So I am a gracious passenger, he says.
No,
that is
you
not.
had also a goods in the truck. It's not been disputed.
There is no issue. But the letter member of the tribunal held that I am a courteous passenger. That this is what a courteous passenger. That is the case.
Here in Pera. Allahabad, it's final, this Allahabad. This final.
Yes.
Not required.
Not required, of course.
I think that is enough.
Yes, I want to
If it is the same,
I want to come to the
only one case will be quoted, the important,
Yes.
the relevant one, if it is all the same. Even if you relied on the 100 also, if it is same, no.
I want to
not
come before
required.
your lordship
Hmm.
regarding the powers of the appellate court under Order 41, Rule 33.
Hmm.
Order 41, Rule 33, this court has ample power to pass any await orders. Whether a ground has been taken in the appeal or an objection has been raised, it is immaterial. When the subject matter is placed before the appellate court under Order 41, Rule 33, because this MEC appeal is to be, the proceeding is to be conducted under Order 41, Rule 1. So the power of the appellate court is specified in Order 41, Rule 33. So in the exercise of the powers under Order 41, Rule 33, this Honorable Court has ample power to grant appropriate relief. When the grounds are taken in the memo of appeal, it is not material. So regarding the consortium, here the learned member of the tribunal has granted the consortium in a very limited amount.
So you are coming to the quantum.
Yes, another point on the quantum.
Is it in your pleadings?
No, I have not agitated this.
Hmm?
I have not agitated this.
Then it's fine only.
But I want to invoke the jurisdiction of your lordship.
I think that will be sufficient. You first ensure that you get at least. Now the person whom it was directed, that could not be found out.
I want to invoke the
You
honorable.
should satisfy ensuring that if it is directed to the insurance company. It may or may not be, of course.
Here, consortium is granted only in favor of the wife, payment number one. New consortium was granted to the three.
How much you are entitled?
Three
How much they
minor
have given?
sons. I am entitled for rupees 40,000 each. Each of the three minor claimants.
This is based on which?
This is based on the judgment rendered
Sarla
by.
Verma.
Yeah, it is constitutional bench decision onwards.
Sarla Verma.
Yes. I mean, Paraner T. I want to first refer to a three-judge bench decision of the Honorable
So
Supreme
if
Court.
this has not been agitated, I don't
But
think that we can go beyond pleadings at this
I
stage.
want to take leave of your lordship.
We'll deal with it.
I want to take the leave permission of your lordship to allow me to at least
No, it's fine only. We have not agitated.
but
Let us not go beyond the pleadings.
But at least for fairness and justice, the three sons.
First, let us decide this.
The three.
First, let us decide this if the insurance can be made liable.
Yeah, that is the usual ground.
This authorities regarding you are going to show is
No, Lordship, please,
this is regarding
please, I pray before your Lordship that I may be allowed to cite at least one of the decisions.
sitting there. So what do you want to show?
Here, kindly see paragraph number 3. Paragraph number 3. Yeah, I mean paragraph number 8, step 3. Paragraph number 8, step 3. Paragraph number 8, step 3. That is the page 2137. Paragraph number 8, step 3, bracket small e and bracket small p.
Para 8.
Paragraph number 8, step 3. Step 1, 2, 3 are provided. So step 3, bracket small e and bracket small p. Yes. Lordship, shall I read?
Laws of consortium.
Yes. Bracket small e.
Just a minute.
In respect of consortium, there are 3 conventional heads.
But your accident it took place
In
in 2014.
No, Lordship, this I mean to say the conventional
The decision is
conventional
2020.
compensation,
This is 2020.
not the statutory liability, but it is a conventional award, which is consortium. So 3 conventional heads.
Yes.
Yes, here.
I think it's fine only. Because this is, you are now coming to the quantum, which you have not pleaded.
Yes.
Let us not go beyond that.
No,
Beyond the pleading.
it's all right.
Hmm.
It's up to your Lordship. I place it before your Lordship.
It will create confusion.
I place it before your Lordship.
Yes. Anything else?
Okay.
Okay.
34.
Okay. Anything?
Lordship, I have some ruling to Lordship,
Okay.
short ruling to Lordship.
Hmm.
Lordship, before coming to the ruling, your Lordship. Lordship, before coming to the ruling, your Lordship, it is clear from the observation made by the tribunal as well as this by the statement of the learned counsel, your Lordship, that there is no dispute regarding as to the offending driver was not a good carrier vehicle, your Lordship.
The truck was not. Huh?
There's no dispute regarding whether it was a good vehicle or not, your Lordship.
Hmm.
Your Lordship, as per the records, your Lordship, and the facts, your Lordship, it was a truck, good carriage vehicle, your Lordship. And your Lordship, this is your Lordship, was a courageous person as and when he aborted the said vehicle, your Lordship. Now, your Lordship, coming to the citation, your Lordship. Lordship, These are similar citations as referred by the learned counsel, Your Lordship.
Yes.
Lordship,
This
channel number
regarding-
one. Regarding liability, Your Lordship, the whole issue here is regarding who is liable to pay the insured amount, Your Lordship. Now, Your Lordship, coming to the first citation 2004 to SSC 711, Your Lordship.
Okay.
Lordship, part 20,
Para
Your
20.
Lordship. Yes, Your Lordship. Page number 8, Your Lordship.
Yes.
Lordship, if I may be allowed to read, Your Lordship.
Yes.
It is therefore manifest that in spite of the amendment of 1999 and the effect of the provisions contained in section,
1994.
yes, Your Lordship. Section, Your Lordship. Although the owner of the vehicle goods and his authorized representation would now be covered by the policy insured.
Don't mix. Don't mix up. That is not.
Lordship, if I may,
Yes,
Your
it
Lordship.
is therefore manifest that.
Yes,
in
Your
spite
Lordship.
of
Your Lordship,
amendment-
coming to the second sentence, Your Lordship. Although
Yes.
the owner of the goods or his authorized representative respective would now be covered by the policy of insurance in respect of a good vehicle. It was not the intention of the legislature, Your Lordship, to provide for liability of the insurers with respect to passengers, especially gratuitous passenger, who were neither contemplated at the time of the contract of the insurance, Your Lordship. Your Lordship, this is important, Your Lordship.
Who were neither contemplated
At the time of the contract of insurance
the
was entered into, Your Lordship, nor any premium paid to the extent of the benefits of the insurance to such category, Your Lordship. Lordship, it is clear, Your Lordship. Gratuitous passenger, Your Lordship. Just make it quick, Your Lordship. Your Lordship, coming to the second citation, Your Lordship.
goods for his authorized representative.
Your Lordship.
Now, although the owner of the goods or his
Yes, Your
authorized
Lordship.
representative would now be covered
Yes, Your Lordship.
by the policy of insurance
Yes, Your
in
Lordship.
respect to the goods vehicle. It was not the intention of the, okay,
Not the intention of the legislature to provide for liability who were neither contemplated at the time the contract of issue was entered into, nor was any premium paid to the extent of the benefit of the insured to such category of goods.
okay.
Lordship, coming to the second citation, Your Lordship.
Hmm.
Page number 11, Your Lordship. Lordship,
Yes.
here similar, Your Lordship.
Page 9.
The citations, Your Lordship, just
Para 10.
part in, Your Lordship.
Hmm.
Lordship, similar, Your Lordship, if I may be allowed to go to the next citation. Lordship, third citation, Your Lordship.
Okay.
Page number 14, Your Lordship.
Page 14.
Yes, Your Lordship.
Yes.
Para 7, Your Lordship.
Yes.
Lordship, this is regarding the gratuitous compensation. Your Lordship, if I may be
Yes.
allowed to read. In Asha Rani, this court, while overruling the Satpal Singh, have clearly held that the insurance company is not liable to pay for any compensation for death of gratuitous passenger traveling in a goods vehicle.
So you're still saying that he
Yes, Your Lord.
was a
Yes, Your
gratuitous
Lordship.
passenger.
Yes, Your Lordship.
And
Your Lordship, as in when he aborted, Your Lordship, he became a gratuitous person, Your Lordship.
okay.
Your Lordship, coming to.
So despite that he paid
Yes, Your Lordship.
freight charge
Yes, Your
and he
Lordship.
had a goods.
Yes, Your Lordship.
So but you're still saying that he was a
Gratuitous
gratuitous
passenger, Your
passenger.
Lordship.
Okay.
Your Lordship, owner of goods is mentioned, Your Lordship. It's clear. There's no rejection to that, Your Lordship. But owners of a gratuitous passenger is neither mentioned anywhere in the contract or the citation, Your Lordship.
But then when it is the policy is for the carriers,
Yes, Your Lordship.
goods carrier,
Yes, Your Lordship.
probably it covers.
Lordship, probably what has happened is that a food carrier, vehicle carrier,
And then as per the
from one point to the
as per
other.
the citation.
Yes, Your Lordship.
Various citation that you have also.
Yes,
had.
Your Lordship.
Hmm.
In Your Lordship,
Okay. Now para 20.
part 20, Your Lordship. Just a short.
Para 20 is at page 17. Yes.
Yes, Your Lordship. Lordship, similar, Your Lordship, if I may be allowed to come to
Okay. Similar.
citation
Okay.
number 4,
Then,
Your Lordship.
Next citation.
Para 8 and 11, Your Lordship.
Para
Page number 22, Your Lordship.
22.
Yes, Your Lordship. The para reflected as 11, Your Lordship.
Yes.
Our view gets supported from the recent decision of the three judges bench of this court in New India Insurance Corporate Limited versus Asha Rani, in which it has been held that Satpal Singh case was not correctly decided. That being the position, the tribunal and the High Court were not justified in holding that the insurer had the liability to pay to satisfy the award. The position was so highlighted in the Oriental. Your Lordship, coming to the next line, Your Lordship. Above being the position, the impugned judgment is not sustained and is set aside. It is open to the claimant to recover the amount from the owner of the offended vehicle, Your Lordship. Your Lordship, here similar matter was done. Similar matter where the gratuitous passenger have died in the accident.
Okay, now
Where
it's indicating that from the
owner of the vehicle, Your Lordship.
can
This
claim
period.
from the owner of the vehicle.
Yes, Your Lordship.
In the instant case, according to you, rightly granted.
Yes, Your Lordship. And in the instant case of the tribunal have observed that the award should be given by the owner, not the insurance company, since there was violation of the insurance policy, Your Lordship. Your Lordship, coming to the citation number 5, Your Lordship. Your Lordship, page number 7, Your Lordship, page number 28.
Yes.
Your Lordship, this is a judgment passed by the Honorable High Court, Gauhati High Court, Your Lordship, on page 29, Your Lordship, 16/3/2024, Your Lordship. Your Lordship, relevant part will find page 30, para 8, Your Lordship.
Para 8.
Yes, Your Lordship.
Yes.
In view of the laws laid down in National Insurance Corporation Limited versus Boniti Subhayaman Supra, it can be said that since the insurance company is not liable to pay compensation for the death of gratuitous passenger in a good service, the tribunal erred by directing the insurance company to pay the compensation and to go for recovery of the same from the said owner of the vehicle.
Directing
The
committed error. Okay.
insurance company to pay the compensation and to go for recover for the same from the owner of the vehicle, Your Lordship. This is also one judgment, Your Lordship, regarding gratuitous passenger, Your Lordship.
Now, this is talking about the gratuitous person.
Yes, Your
What is the
Lordship.
fact
Yes,
of
Your
the case? Whether he traveled, he had a goods.
No, Your Lordship.
Okay, this is different, I think.
Yes,
the
Your
fact-
Lordship.
This case probably is a
Yes, Your Lordship. He was traveling by a pickup truck, Your
pickup
Lordship.
truck only.
Pickup
Oh.
truck, Your Lordship.
Okay.
Your Lordship, the main ground for consideration here is the liability, Your Lordship, whether he
Yes.
was a gratuitous person or not, Your Lordship.
Okay. Anything else?
Yes, Your Lordship. And Your Lordship, as per by the policy of the insurance company, Your Lordship, it is clear that the driver and the handyman was only the licensed passenger, Your Lordship,
Okay.
person to be traveling from the truck, Your Lordship.
Okay.
Lordship.
So according to you, it must go.
Yes, Your Lordship.
Okay. Okay. Hard, Mr. You are Tali.
Tally.
Hard, Mr. Tali. Land Council for the appellant. Stop. I have also heard Mr. M. Solo. No, appellant, claimant.
Appellant.
I am for the appellate.
Claimant.
Claimant appellate.
Okay. Appellant, stroke, claimant. Start. I have also heard Mr. M. Solo, Land Council, appearing on behalf of
2 and
the
3, Your Lordship.
respondent number 2 and
3.
3. One is
The owner.
One is
Okay.
the owner of the truck, ex-party.
expert.
Yes.
Is there any order?
No, the owner was,
Is there any order? Proceeding
yes,
ex
yes,
parte against-
ex-party has been already
Okay.
directed because
Okay.
it was published in the newspaper.
Okay.
Newspaper return has been filed.
By which order it was passed, decided that it will proceed against
Respondent number four, na?
Respondent one.
17/2/2023, Your Lordship.
17 to
2023.
2020,
2023.
23.
Mm.
17 to
17/2.
23.
There's no other.
No, no, no,
2023.
Lordship. 21/2/2023.
21.
21/2/2023.
Completed. Respondent one.
One. Lordship, in respect of respondent number one, 2/9/2022. 2/9/2022. Respondent number tin to be complete. This one. Respondent number 2, 3. Insurance company.
Yeah.
No one appears on behalf of the respondent number one. No, since no one appeared on behalf of the respondent number one, comma, there, and this appeal proceeded ex parte against the respondent number one. Okay, stop. Huh? Para. Para, huh? Hearing concluded. Stop, para. Judgment reserved. Okay. What is that?
It's just,
Appellate. No, this is. I've collected this. Possible. 2013 554. This we have 2005 12. Have you marked? Yeah, printed off. Printed off. Okay. These all printed. Yeah. Okay, that is fine. And the one that they have given, this is here. Okay. And this, that is not required. Okay, so this keep it. This also. Along with that. One. This. And then along with that, this also will go. Along with the file. Along with that, along with the file. This will not be required.